I'd like to welcome you to the meeting of the Standing Committee on Justice and Human Rights. As we resume our meetings on the study of remediation agreements, the shock cost doctrine, and the discussions between the Office of the Attorney General and government colleagues as relates to SNC-Lavalin, I would very much like to thank our witness today, the Honourable Jody Wilson-Raybould, our colleague from Vancouver-Grenville, who has agreed to come before us today. As opposed to our standard practice of allotting witnesses 10 minutes, we all have agreed to afford Ms. Wilson-Raybould 30 minutes in order to be able to more fully tell her story. She is at the center of the events we're studying, and I think it's really important to give her that time. I would, of course, advise other witnesses that will not be the normal practice of the committee. Before we begin Ms. Wilson-Raybould's testimony, Mr. Rankin has advised me he has a point that he wishes to raise, and I don't want her to eat into Ms. Wilson-Raybould's time. So I'll ask Mr. Rankin to give his point.
Thank you very much, Chair. There's actually two kind of related points. The first is that when she accepted our invitation, Ms. Wilson-Raybould wrote us, and I quote, "I will remain before the committee to answer questions for as long as the committee wishes." Now, you'll recall, Mr. Chair, that when we also extended time for Mr. Wernick, the clerk of the Privy Council office, and he was willing to stay longer as well. So I'd like to move that the committee accept her offer and allow her to spend longer with us either today or at some subsequent meeting. That's my first point. And the second was, since she's going to do a very lengthy statement in terms of how we've proceeded in the past, I'd like to ask if there is a written statement, if it could be distributed while she's speaking, because, of course, we will have even less time for questioning than usual as a result, and would give us, I think, more efficiency in asking questions if we had that statement before us in advance. Those are my two suggestions.
Thank you, Mr. Rankin. As to the first suggestion, I'm wondering if Ms. Wilson-Raybould does indeed have a statement that she would like to be distributed to the committee, or would she prefer? Because I think this is. I would like to go to her preference. What would she prefer?
I do have a statement. It's been provided to the translators, and if it is the will of the committee, they can distribute that to members.
So as soon as then copies are ready, Mr. Clerk, the committee agreed to have that statement in English only. Okay. We need. Mais on va le fournir dès que c'est possible.
We'll provide it as soon as possible, Mr. Fortin. We will provide it to you in French as soon as possible. You don't have it available right now. No, that's why I asked for unanimous consent from the committee to distribute it. And as I'm not a member of the committee, I can't vote. But I'd like to have a copy in English and a French one as soon as possible, as soon as it's ready.
So I think I have unanimous consent, so the clerk can distribute that. And as to the proposal, I very much appreciated Ms. Wilson-Raybould's offer to stay longer for questions. Our standard is 2 rounds. So I think there's agreement that we'll go longer than 2 rounds, and then let's take it round by round after round 3. We went for 3 with Mr. Wernick, then let's talk round by round if you have more questions.
Thank you, Chair.
Thank you very much. So would you like Mr. Rankin to get the statement before Ms. Wilson-Raybould begins, or can we begin?
That would be my preference if it could be made available.
How long will it be?
Well, at least 5-10 minutes.
Oh, it'll be 5 or 10 minutes. So I think it's only fair to the witness to let her begin. Ms. Wilson-Raybould, the floor is yours, and when we get to 30 minutes, I'll just give you a sort of sign to let you know that it's there, okay? Thank you so much, Ms. Wilson-Raybould. The floor is yours.
Well, Gaila Kusla, thank you, Mr. Chair, and thank you to the members of the Justice Committee for providing me the opportunity for extended testimony today. I very much appreciate it. And starting off, I would like to acknowledge the territory, the ancestral lands of the Algonquin people. For a period of approximately 4 months between September and December of 2018, I experienced a consistent and sustained effort by many people within the government to seek to politically interfere in the exercise of prosecutorial discretion in my role as the Attorney General of Canada in an inappropriate effort to secure a deferred prosecution agreement with SNC-Lavalin. These events involved 11 people, excluding myself and my political staff, from the Prime Minister's office, the Privy Council office, and the Office of the Minister of Finance. This included in-person conversations, telephone calls, emails, and text messages. There were approximately 10 phone calls and 10 meetings specifically about SNC, and I and/or my staff were a part of these meetings. Within these conversations, there were expressed statements regarding the necessity of interference in the SNC-Lavalin matter, the potential of consequences, and veiled threats if a DPA was not made available to SNC. These conversations culminated in December the 19th of 2018 with a conversation I had with the clerk of the Privy Council, a conversation that I will provide some significant detail on. A few weeks later, on January the 7th, 2019, I was informed by the Prime Minister that I was being shuffled out of the role of Minister of Justice and Attorney General of Canada. For most of these conversations, I made contemporaneous notes, detailed notes, in addition to my clear memory, which I am relying on today, among other documentation. My goal in my testimony is to outline the details of these communications for the committee and indeed all Canadians. However, before doing that, let me make a couple of comments. First, I want to thank Canadians for their patience since the February 7th story, which broke in the Globe and Mail. Thank you as well, specifically to those who have reached out to me across the country. I appreciate the messages and I have read all of them. Secondly, on the role of the Attorney General. The Attorney General exercises prosecutorial discretion as provided for under the Director of Public Prosecutions Act. Generally, this authority is exercised by the Director of Public Prosecutions, but the Attorney General has authority to issue directives to the DPP on specific prosecutions or to take over prosecutions. It is well established that the Attorney General exercises prosecutorial discretion. She or he does so individually and independently. These are not Cabinet decisions. I will say that it is appropriate for Cabinet colleagues to draw to the Attorney General's attention what they see as important policy considerations that are relevant to decisions about how a prosecution will proceed. What is not appropriate is pressing the Attorney General on matters that she or he cannot take into account, such as partisan political considerations, continuing to urge the Attorney General to take her or his mind for months after the decision has been made, or suggesting that a collision with the Prime Minister on these matters should be avoided. With that said, the remainder of my testimony will be a detailed and factual delineation of approximately 10 phone calls, 10 in-person meetings, and emails and text messages that were part of an effort to politically interfere regarding the SNC matter for purposes of securing a deferred prosecution. The story begins on September the 4th, 2008. My chief of staff and I were overseas when I was sent a memorandum for the Attorney General pursuant to Section 13 of the Director of Public Prosecutions Act, which was entitled, quote, whether to issue an invitation to negotiate a remediation agreement to SNC-Lavalin, end quote, which was prepared by the Director of Public Prosecutions, Kathleen Roussel. The only parts of this note that I will disclose are as follows. Quote, the DPP is of the view that an invitation to negotiate will not be made in this case and that no announcement will be made by the PPSC, end quote. As with all Section 13 notices, the Director provides the information so that the Attorney General can take such course of action as they deem appropriate. In other words, the Director had made her decision to not negotiate a remediation agreement with SNC-Lavalin. I subsequently spoke to my minister's office staff about the decision, and I did the standard practice of undertaking further internal work and due diligence in relation to this note, a practice that I have had for many of the Section 13 notices that I received when I was the Attorney General. In other words, I immediately put in motion with my department and minister's office a careful consideration and study of the matter. 2 days later, on September the 6th, one of the first communications about the DPA was received from outside of my department. Ben Chin, Minister Morneau's chief of staff, emailed my chief of staff and they arranged to talk. He wanted to talk about SNC and what we could do, if anything, to address this. He said to her, my chief, that if they don't get a DPA, they will leave Montreal, and it's the Quebec election right now, so we can't have that happen. He said that they have a big meeting coming up on Tuesday and that this bad news may go public. This same day, my chief of staff exchanged some emails with my minister's office staff about this, who advised her that the Deputy Attorney General, Nathalie Drouin, was working on something and that my staff were drafting a memo about the role of the Attorney General vis-a-vis the PPSC. It was on or about this day that I requested a one-on-one meeting with the Prime Minister on another matter of urgency, and as soon as possible after I got back into the country. This request would ultimately become the meeting on September the 17th between myself and the Prime Minister that has widely been reported in the media. On September 7th, my Chief of Staff spoke by phone to my then Minister, or Deputy Minister, about the call she had received from Ben Chin, and the Deputy stated that the department is working on this. The Deputy gave my Chief a quick rundown of what she thought some options would be. On the same day, I received a note from my staff on the role of the Attorney General, a note that I also shared with that my office also shared with Elder Marquez and Amy Archer at the PMO. Same day, staff in my office met with the Deputy Minister. Some excerpts of the Section 13 note were read to the Deputy Minister, but the Deputy Minister did not want to be provided with a copy of the Section 13 note. September 8th. My deputy shared the draft note on the role of the Attorney General with my Chief of Staff, who subsequently shared it with me. And over the next day, clarity was sought by my staff with the deputy on aspects of the options that were laid out in her note. A follow-up conversation between Ben Chin and a member of my staff, Francois Giroux, occurred on September the 11th. Mr. Chin said that SNC had been informed that by the PPSC that it cannot enter into a DPA. And Ben again detailed the reasons why they were told that they were not getting a DPA. Mr. Chin also noted that SNC's legal counsel, Frank Iacobucci, and further detailed what the terms were that SNC was prepared to agree to, stating that they viewed this as part of a negotiation. To be clear, up to this point, I had not been directly contacted by the Prime Minister, officials in the Prime Minister's office, or the Privy Council office about this matter. With the exception of Mr. Chin's discussions, the focus of communications had been internal to the Department of Justice. This changes on September the 16th. My Chief of Staff had a phone call with Mathieu Bouchard and Elder Marquez from the Prime Minister's office. They wanted to discuss SNC. They told her that SNC had made further submissions to the Crown and that there is some softening, but not much. They said that they understood that the individual Crown prosecutor wants to negotiate an agreement, but the director does not. They said that they understand that they're direct, but that they hear that our Deputy of Justice thinks we can get the PPSC to say, we think that we should get some outside advice on this. They said that they think we should be able to find a more reasonable resolution here. They told her that SNC's next board meeting is on Thursday, which was September the 20th. They also mentioned the Quebec election context. They asked my chief if someone has suggested the outside idea to the PPSC and asked whether or not we were open to this suggestion. They wanted to know if my deputy could do it. In response, my Chief of Staff stressed to them prosecutorial independence and potential concerns about the interference in the independence of the prosecutorial functions. Mr. Bouchard and Mr. Marquez kept telling her that they didn't want to cross any lines, but they asked my Chief of Staff to follow up with me directly on this matter. To be clear, I was fully aware of the conversations between September the 4th and 16th that I have outlined. I had been regularly briefed by my staff from the moment this first arose and had also reviewed all materials that had been produced. Further, my view had also formed at this point. Through the work of my department, my minister's office, and work I conducted on my own, that is what was inappropriate, that it was inappropriate for me to intervene in the decision of the Director of Public Prosecutions in this case and to pursue a deferred prosecution agreement. In the course of reaching this view, I discussed the matter on a number of occasions with my then deputy so that she was aware of my view, raised concerns on a number of occasions with my deputy minister about the appropriateness of communications we were receiving from outside the department, and also raised concerns about some of the options that she had been suggesting. On September 17th, the deputy minister said that finance had told her that they wanted to make sure that Kathleen understands the impact if we do nothing in this case. Given the potential concerns raised by this conversation, I discussed this later with my deputy. This same day, September 17th, I have my one-on-one meeting with the Prime Minister that I requested a couple of weeks ago. When I walked in, the clerk of the Privy Council was in attendance as well. While the meeting was not about the issue of SNC and DPAs, the Prime Minister raised the issue immediately. The Prime Minister asked me to help out, to find a solution here for SNC, citing that if there is no DPA, there would be many jobs lost and that SNC would move from Montreal. In response, I explained to him the law and what I have the ability to do diligence and had made up my mind on SNC and that I was not going to interfere with the decision of the director. In response, the Prime Minister reiterated his concerns. I then explained how this came about and that I had received a Section 13 note from the DPP earlier in September and that I had considered the matter very closely. I further stated that I was very clear on my role as the Attorney General and that I am not prepared to issue a directive in this case, that it would not be appropriate. The Prime Minister again cited the potential loss of jobs and SNC moving. Then, to my surprise, the clerk started to make the case for the need for a DPA. He said, quote, "There is a board meeting on Thursday, September the 20th, with stockholders," end quote. Quote again, "They will likely be moving to London if this happens, and there is an election in Quebec soon," end quote. At that point, the Prime Minister jumped in, stressing that there is an election in Quebec and that, quote, "I am an MP in Quebec, the member for Papineau," end quote. I was quite taken aback. My response, and I vividly remember this as well, was to ask the Prime Minister a direct question while looking him in the eye. I asked, quote, "Are you politically interfering with my role, my decision as the Attorney General? I would strongly advise against it," end quote. The Prime Minister said, no, we just need to find a solution. The clerk then said that he spoke to my deputy and she said that I could speak to the director. I responded by saying, no, I would not. That would be inappropriate. I further explained to the clerk and the Prime Minister that I had had a conversation with my deputy about options and what my position was on the matter. As a result, I agreed to and undertook to the Prime Minister that I would have a conversation with my deputy and the clerk, but that these conversations would not change my mind. I also said that my staff and my officials are not authorized to speak to the PPSC. And then we finally discussed the issue that I had asked for the meeting in the first place. I left the meeting and immediately debriefed with my staff about what was said with respect to SNC and DPAs. On September 19th, I met with the clerk as I had undertaken to the Prime Minister. The meeting was one-on-one in my office. The clerk brought up job losses and that this is not about the Quebec election or the Prime Minister being a Montreal MP. He said that he has not seen the Section 13 note. The clerk said that he understands that SNC is going back and forth with the DPP and that they want more information. He said that, quote, "Iacobucci is not a shrinking violet," end quote. He referenced the September 20th date and that they don't have anything from the DPP. He said that the Prime Minister is very concerned about the confines of my role as Attorney General and the Director of Public Prosecutions. He reported that the Prime Minister is very aware of my role as the Attorney General of Canada. I told the clerk again that I instructed my deputy that my deputy is not to get in touch with the director, and that given my review of the matter, I would not speak to her directly regarding the ADPA. I offered that if SNC were to send, I offered to the clerk, if that SNC were to send me a letter expressing their concerns, their public interest argument, it would be permissible and I would appropriately forward it directly to the Director of Public Prosecutions. Later that day, my Chief of Staff had a phone call with Elder Marquez and Mathieu Bouchard from the Prime Minister's office. They wanted an update on what was going on regarding the DPAs since, quote, we don't have a ton of time, end quote. She relayed my summary of the meeting with the clerk and the Prime Minister. Mathieu and Elder also raised the idea of a, quote, informal reach out, end quote, to the DPP. My Chief of Staff said that she knew I was not comfortable with that, as it looked like and probably did constitute political interference. They asked whether that was true if it wasn't the Attorney General herself, but if it was her staff or the Deputy Minister. My Chief of Staff said yes, it would, and offered a call with me directly. They said that they will regroup and get back to you on that. Still on September the 19th, I spoke to Minister Morneau on this matter when we were in the House. He again stressed the need to save jobs, and I told him that engagements from his office to mine on SNC had to stop, that they were inappropriate. They did not stop. On September the 20th, my Chief of Staff had phone calls with Mr. Chin and Justin Toh, both members of the Minister of Finance's office, about DPAs and SNC. At this point, after September the 20th, there was an apparent pause in communicating with myself or my Chief of Staff on the SNC matter. We did not hear from anyone again until October the 18th, when Mathieu Bouchard called my Chief of Staff and asked that I look at the option of seeking an external legal opinion on the DPP's decision not to extend an invitation to negotiate a DPA. This would become a recurring theme for some time in messages from the PMO that an external review should be done of the DPP's decision. The next day as well, SNC filed a federal court application seeking to quash the DPP's decision to not enter into a remediation agreement with them. In my view, this necessarily put to rest any notion that I might speak to or intervene with the DPP or that external review could take place. The matter was now before the courts and a judge was being asked to look at the DPP's discretion. However, on October the 26th, 2018, when my Chief of Staff spoke to Mathieu Bouchard and communicated to him now that given that SNC has now filed in federal court seeking to review the DPP's decision, surely we had moved past the idea of the Attorney General intervening or getting an opinion on the same question. Mathieu replied that he was still interested in an external legal opinion idea. Could she not get an external legal opinion on whether the DPP had exercised their discretion properly? And then, on the application itself, the Attorney General could intervene, seek to stay the proceedings, given that she was awaiting a legal opinion. My Chief of Staff said that this would obviously be perceived as interference and her boss questioning the DPP's decision. Mathieu said that if 6 months from the election, SNC announces they're moving their headquarters out of Canada, that is bad. He said, quote, we can have the best policy in the world, but we need to get reelected, end quote. He said that everybody knows that this is the Attorney General's decision, but that he wants to make sure that all options are being canvassed. Mathieu said that if, at the end of the day, the Attorney General is not comfortable, that is fine. He just doesn't want any doors to be closed. Jessica, my Chief of Staff, said that I was always happy to speak to him should he wish. In mid-November, the PMO requested that I meet with Mathieu Bouchard and Elder Marquez to discuss the matter, which I did on November 22nd. This meeting was quite long. I would say about an hour and a half. I was irritated by having to have the meeting, as I had already told the Prime Minister, etc., that a DPA on SNC was not going to happen, that I was not going to issue a directive. Mathieu in this meeting did most of the talking. He was trying to tell me that there were options and that I needed to find a solution. I took them through the DPP Act, Section 15, Section 10, and talked about the prosecutorial independence as a constitutional principle, and that they were interfering. I talked about the Section 13 note, which they said they had never received, but I reminded them that we sent it to them in September. Mathieu and Elder continued to plead their case, talking about if I'm not sure in my decision that we could hire an eminent person to advise me. They were kicking the tires. I said no. My mind had been made up and they needed to stop. This was enough. I will briefly pause at this moment to comment on my own state of mind. In my role as Attorney General, I had received the decision of the DPP in September, had reviewed the matter, made a decision on what was appropriate given a DPA, and communicated that to the Prime Minister. I had also taken additional steps that the Prime Minister asked me to, such as meeting with the clerk. In my view, the communications and efforts to change my mind on this matter should have stopped. Various officials also urged me to take partisan political considerations into account, which it was clearly improper for me to do so. We either have a system that is based on the rule of law, the independence of prosecutorial functions, and respect for those charged to use their discretion and powers in a particular way, or we do not. While in our system of government, policy-oriented discussion amongst people at early points in this conversation may be appropriate, the consistent and enduring efforts, even in the face of judicial proceedings on the same matter, and in the face of a clear decision of the Director of Public Prosecutions and the Attorney General to continue and even intensify such efforts, raises serious red flags in my view. Yet, this is what continued to happen. On December the 5th of 2018, I met with Jerry Butts. We had both sought out this meeting. I wanted to speak about a number of things, including bringing up SNC and the barrage of people hounding me and my staff. Towards the end of our meeting, which was in the Chateau Laurier, I raised how I needed everybody to stop talking to me about SNC, as I had made up my mind and the engagements were inappropriate. Jerry then took over the conversation and said how we need a solution on the SNC stuff. He said I needed to find a solution. I said no, and I referenced the preliminary inquiry and the judicial review. I said further that I gave the clerk the only appropriate solution that could have happened, and that was the letter idea that was not taken up. Jerry talked to me about how the statute was a statute passed by Harper and that he does not like the law. I said something like, that is the law that we have. On December the 7th, I received a letter from the Prime Minister dated December 6th, attaching a letter from the CEO of SNC-Lavalin dated October the 15th. I responded to the Prime Minister's letter on December 6th, noting that the matter is before the court, so I cannot comment on it, and that the decision re a DPA was one for the DPP, which is independent of my office. This brings me to the final events in the chronology, the ones that signal, in my experience, the final escalation in efforts by the Prime Minister's office to interfere in this matter. On December 18th of 2018, my Chief of Staff was urgently summoned to a meeting with Jerry Butts and Katie Telford to discuss SNC. They wanted to know where I am at in terms of finding a solution. They told her that they felt like the issue was getting worse and that I was not doing anything. They referenced a possible call with the Prime Minister and the clerk the next day. I will now read to you a transcript of the most relevant sections of a text conversation between my Chief of Staff and I almost immediately after that meeting. Jessica, Basically, they want a solution, nothing new. They want external counsel retained to give you an opinion on whether you can review the DPP's decision here and whether you should in this case. I told them that would be interference. Jerry said, quote, "Jess, there is no solution here that does not involve some interference," end quote. At least they are finally being honest about what they are asking you to do. Don't care about the PPSC's independence. Katie was like, quote, "We don't want to debate legalities anymore," end quote. They keep being like, "We aren't lawyers, but there has to be some solution here." Mojag, I text. So where were things left? Jessica, so unclear. I said would of course let you know about the conversation, and they said that they were going to kick the tires with a few people on this tonight. The clerk was waiting outside when I left. But they said that they want to set up a call between you and the Prime Minister and the clerk tomorrow. I said that of course you'd be happy to speak to your boss. They seem quite keen on the idea of you retaining an ex-Supreme Court of Canada judge to get advice on this. Katie Telford thinks it gives us cover in the business community and the legal community, and that it would allow the Prime Minister to say we were doing something. She was like, quote, "If Jody is nervous, we would of course line up all kinds of people to write op-eds saying that what she is doing is proper," end quote. On December the 19th, 2018, I was asked to have a call with the clerk. It was a fairly lengthy call, and I took the call from home, and I was on my own, by myself. Given what occurred the previous day with my chief of staff, I was determined to end all interference and conversations about this matter once and for all. Here's part of what the clerk and I discussed. The clerk said he was calling about DPA's SNC. He said he wanted to pass on where the Prime Minister is at. He spoke about the company's board and the possibility of them selling out to someone else, moving their headquarters, and job losses. He said that the Prime Minister wants to be able to say that he has tried everything he can within the legitimate toolbox. The clerk said that the Prime Minister is quite determined, quite firm, but he wants to know why the DPA route, which Parliament provided for, isn't being used. He said, quote, "I think he is going to find a way to get it done, one way or another." So he is in that kind of mood, and I wanted you to be aware of it, end quote. The clerk said he didn't know if the Prime Minister was planning on calling me directly or if is thinking about getting somebody else to give him some advice. You know, he does not want to do anything outside of the box of what is legal or proper. He said that the Prime Minister wants to understand more, to give him advice on this, or give you advice on this if you want to feel more comfortable you are not doing anything inappropriate or outside the frame. I told the clerk that I was 100% confident that I was doing nothing inappropriate. I again reiterated my confidence in where I am in my views on SNC and the DPA have not changed. I reiterate this is a constitutional principle of prosecutorial independence. I warned the clerk in this meeting that he was in this call that we were treading on dangerous ground here. I also issued a stern warning because as the Attorney General, I cannot act in a manner, and the prosecution cannot act in a manner that is not objective, that isn't independent. I cannot act in a partisan way, and I cannot be politically motivated. This all screams of that. The clerk wondered whether anyone could speak to the director about the context around this or get her to explain her reasonings. The clerk told me that he was going to have to report back to the Prime Minister before he leaves. He said again that the Prime Minister was in a pretty firm frame of mind about this, and that he was a bit worried. I asked what he's worried about. The clerk then made the comment about how it is not good for the Prime Minister and his Attorney General to be at loggerheads. I told the clerk that I was giving him my best advice and that if he did not accept that advice, then it is the Prime Minister's prerogative to do what he wants. But I am trying to protect the Prime Minister from political interference or perceived political interference or otherwise. The clerk acknowledged that, but said that the Prime Minister does not have the power to do what he wants. All the tools are in my hands, he said. I said that I was having thoughts of the Saturday night massacre, but that I was confident that I had given the Prime Minister my best advice to protect him and to protect the constitutional principle of prosecutorial independence. The clerk said that he was worried about a collision between the Prime Minister, because the Prime Minister is pretty firm about this. He told me that he had seen the Prime Minister a few hours ago and that this is really important to him. That is essentially where the conversation ended, and I did not hear from the Prime Minister the next day.
I'm just letting everybody know that as chair, I choose to give you more than 30 minutes. You've exceeded it. I'd like you to be able to finish your statement. Is there anybody that has any objection to that? Okay, so please continue.
I don't think anyone in the audience does either.
Thank you, Mr. Chair. On January the 7th, I received a call from the Prime Minister and was informed I was being shuffled out of my role as Minister of Justice and Attorney General of Canada. I will not go into details of this call or subsequent communications about the shuffle, but I will say that I stated I believe the reason was because of the SNC matter. They denied this to be the case. On January the 11th, 2019, the Friday before the shuffle, my former deputy minister is called by the clerk and told that the shuffle is happening and that she will be getting a new minister. As part of this conversation, the clerk tells the deputy that one of the first conversations that the new minister will be expected to have with the Prime Minister will be on SNC Lavalin. In other words, that the new minister will need to be prepared to speak to the Prime Minister on this file. The deputy recounts this to my chief of staff, who tells me about the conversation. My narrative stops here. I must reiterate to the committee my concern outlined in the letter to the chair yesterday. That is, Order in Council number 2019-0105 addresses only my time as the Attorney General of Canada and therefore does nothing to release me from my restrictions that apply to communications while I proudly served as the Minister of Veterans Affairs, and in relation to my resignation from that post or my presentation to Cabinet after I resigned. This time period includes communications on topics that some members of the committee have explored with other witnesses and about which there have been public statements by others. The Order in Council leaves in place the various constraints, in particular Cabinet confidence, that there are on my ability to speak freely on matters that occurred after I left my post as Attorney General. Even with those constraints, I hope that through my narrative today, the committee and everyone across the country who's listening has a clear idea of what I experienced and what I know of who did what and what was communicated. I hope and expect the facts speak for themselves. I imagine Canadians now fully understand that, in my view, these events constituted pressure to intervene in a matter, and that this pressure, or political interference to intervene, was not appropriate. However, Canadians can judge this for themselves, as we now have the same frame of information. Lastly, as I've said previously, it has always been my view that the Attorney General of Canada must be nonpartisan, more transparent in the principles that are the basis of decisions, and in this respect, always willing to speak truth to power. In saying this, I was reflecting what I understood to be the vital importance of the rule of law and prosecutorial independence in our democracy. My understanding of this has been shaped by some lived experiences. I am, of course, a lawyer. I was a prosecutor in the downtown east side of Vancouver. So I come to this view as a trained professional and committed to certain values as key to our system of order. But my understanding of the rule of law has also been shaped by my experiences as an Indigenous person and as an Indigenous leader. The history of Crown Indigenous relations in this country includes a history of the rule of law not being respected. Indeed, one of the main reasons for the urgent need for justice and reconciliation today is that in the history of our country, we have not always upheld foundational values such as the rule of law in relations to Indigenous peoples. And I have seen the negative impacts for freedom, equality, and a just society this can have firsthand. So when I pledged to serve Canadians as your Minister of Justice and Attorney General, I came to it with a deeply ingrained commitment to the rule of law and the importance of acting independently of partisan, political, and narrow interests in all matters. When we do not do that, I firmly believe and know we do worse as a society. I will conclude by saying this. I was taught to always be careful what you say because you cannot take it back. I was taught to always hold true to your core values and principles and to act with integrity. These are the teachings of my parents, my grandparents, and my community. I come from a long line of matriarchs, and I am a truth teller, in accordance with the laws and traditions of our big house. This is who I am, and this is who I always will be. Galakasla, thank you.
Thank you very much, Ms. Wilson-Raybould, for sharing your perspective with the committee. It's much appreciated. So, folks, I'm just going to lay out the rules for the questions. I'm usually a very flexible chair in terms of time, but as we've done for the meetings on this issue, we're going to stick to the time limits. And as a result, I would ask if the witness where somebody's asking for a quick answer it could be a little bit succinct. But I'll obviously want you to be able to finish your answers. So we're going to start. So the first round is 6 minutes Conservative, 6 Liberal, 6 NDP, 6 Liberal, and I'll let everybody know in advance of every round what the time limits are. We'll start with Ms. Wright.
Thank you very much, Ms. Wilson-Raybould. I appreciate your patience on getting here today. It hasn't been an easy path, but I know that Canadians really appreciate it, and they appreciate your testimony today. And I just want to start off by saying that I believe every word that you said today. And I appreciate your honor, and I appreciate your honesty, and I appreciate your integrity and grit in coming forward in the way you have. So I do have some questions, though, and I'd be grateful for your input and your point of view. First and foremost, I'd like to know, the Prime Minister has said that you will be able to discuss all relevant information, but do you believe that there is relevant information that you are unable to include in your 30-minute statement that would be helpful for the committee?
Well, thank you for the comments and the question. As I said in my letter to the committee yesterday, as I said in my remarks today, the extent of the order in council and the waiver of privilege and confidentiality extends to January the 14th, when I was sworn in as the Minister of Veterans Affairs. So it does not include any conversations that occurred thereafter. It does not include conversations that I may or may not have had with the Prime Minister, and it does not include the conversation that I had with my former cabinet colleagues after my resignation from cabinet.
Do you think those would be relevant to our considerations?
Well, I believe that having heard some of the deliberations and questions asked by the committee over the course of the meetings that you've had, some of the questions would be answered if that information was made available.
One of the important pieces of your testimony today were the number of names that you provided for us, giving us a different list of characters that have been involved in this situation since it began in September. I'm wondering if you'd be so kind to provide us with a full list of those names. I've jotted down a few of them, but I don't have the complete listing. Would that be something you'd be willing to do for us?
I believe the full list of names is contained within the remarks that I think are being distributed, but if I counted incorrectly, I will provide all of the names.
I appreciate it. Just on page 14, you mentioned that there were various officials that came forward at the time. If you have any recollection of who the various officials were, that would be helpful for us in terms of making sure we have a complete list of all the witnesses. On January 7, you've pointed out to us that you were told that you were being removed as the Attorney General. As well, you posted a very lengthy Facebook post after your movement to the Minister of Veterans Affairs, but I would assume that you thought a lot about what you would include in a note like this during the time when you were actually Attorney General. And as such, I think and I believe that the statement that you made, even though it was on when you were Minister of Veterans Affairs technically, did come to light and was part of your thought process when you were Attorney General. I just wanted to ask you a couple questions about your Facebook post. The first one, and I quote, it's where, and you mentioned it in your remarks, it has always been my view that the Attorney General of Canada must be nonpartisan, more transparent, and in this respect, always willing to speak truth to power. Do you believe, for the record, that you were removed as the Attorney General because you spoke truth to power on the topic of the SNC ongoing prosecution?
Well, thank you for the question, and I am going to have to be very careful what I say.
I understand.
I believe that I am able to speak to my thought processes from January the 7th up to the time that I was sworn in as the Veterans Affairs Minister.
Yes.
I think it's apparent from my remarks that I was concerned that the reason why I was being shuffled out of the Minister of Justice and Attorney General possibly was because of a decision I would not take on SNC and the DPA. I raised those concerns with the Prime Minister and with Jerry Butts. And as I said in my remarks, those were denied. I cannot speak to anything that I thought about after that point.
I appreciate that. Second part of this letter, you say that the unique and independent aspects of the dual role of the Minister of Justice and the Attorney General of Canada are even more important. I know Canadians across the country expect such high standards to continue to be met, especially in the uncertain times in which we now live, and I expect this to continue. I'd like to know if you are concerned that it's possible that the independence of the Office of the Attorney General is being eroded now, given what you've told us in your testimony today, your understanding that the current Attorney General was to be briefed on the SNC-Lavalin deferment decision.
Well, thanks for the question, and I will not comment on the current Attorney General, but I will comment on when I was the Attorney General and the thoughts that I had when I was on vacation in Bali and when I received a call from the Prime Minister. While I was the Attorney General through these 4 months, leaving aside all of the very inappropriate political pressure, interference, I was confident in my role as the Attorney General that I was the final decision maker on whether or not a directive would be introduced on the SNC matter. So I knew as long as I was the Attorney General, this would not occur. I had concerns that when I was removed as the Attorney General, that this potentially might not be the case. I decided that I would embrace this new role, a very important role, and I really want to say publicly that the role of Veterans Affairs is an incredibly important role, and I took it very seriously. But I had decided to take on the role requested of me by the Prime Minister, but I had concerns, and I knew that in my new role, still sitting around the cabinet table, if there had been a directive that was placed into the Gazette, I would have resigned immediately from cabinet.
Thank you very
Well
much. Ms. O'Connell.
Thank you, Mr. Chair. Thank you for being here today and for providing your notes. I think they're helpful. My set of questions, I want to kind of get a general sense of some timelines. I know you've laid it out here, but just in trying to keep up a little bit. Would you say, or is it fair to say that in and around, and if I have the wrong date, please correct me, September 17th, I think is when you first met with the Prime Minister where it wasn't the purpose of the meeting wasn't at first for the SNC-Lavalin, but it was brought up. And is it fair to say, was it at that point that you felt the questions of your role on this matter, that you were uncomfortable at that point? Or would you say you were uncomfortable from the initial feedback that you heard that your Chief of Staff had been contacted by Mr. Chin? So let's kind of start there.
So there's a couple of questions in
Yeah.
there. If I don't answer them, please let me.
Yeah, no problem.
So the reason for I requested the September 17th meeting, as I said, on an important matter. As I said, the Prime Minister brought up SNC and the Deferred Prosecution Agreement. And with the clerk present, we had conversations about SNC. He brought up SNC about jobs and the potential of job loss. And I will say, entirely appropriate conversations for the Prime Minister to bring up. What I will say is that the conversations turned to be completely inappropriate when there was discussion about the Quebec election, about the fact that the Prime Minister was a member of Parliament in Quebec. It was at that point that I immediately became concerned, and because I was the Attorney General, sought to have a conversation with the Prime Minister about the law, about the role of the Attorney General and the necessary independence that the Attorney General must have in exercising their discretion, in this case around a prosecution. The political concerns that were raised prompted me to ask the question of the Prime Minister directly if he was politically interfering with my role as the Attorney General. So at that point, my senses were heightened. The Prime Minister assured me that that was not the case. But soon thereafter, I instructed my staff and myself as well to ensure that we had a very detailed chronology of all meetings and conversations about SNC and deferred prosecution agreements.
Thank you. So you wouldn't say that it was a red flag necessarily on the topic or the conversations with Mr. Chin on September 7th, because it was those conversations about businesses. It was once the conversation in your mind changed to any politics. Or were you equally concerned on September 7th?
On the earlier meetings prior to the meeting with the Prime Minister, Ben Chin had conversations with my Chief of Staff. And again, in terms of public policy, in terms of having discussions about impacts of decisions and loss of jobs, that was appropriate.
Okay.
But I will say, in those calls, and I don't have my notes in front of me, but I have a pretty generous memory, Mr. Chin raised the Quebec election. And I will say, it's okay to talk about job losses. It's okay to talk about it in initial conversations. But when those topics continue to be brought up after there's a clear awareness that a decision has been made, it becomes inappropriate.
Thank you for clarifying. And sorry, I just want to clarify on that point, because you mentioned you have notes and a pretty good memory. But in the written submission or your verbal remarks, any conversations, at least from September 7th, 8th, I think 11th, at least involving Mr. Chin, were with your staff, not you directly. Did you leave out conversations that you also had, or was it just notes that you had from your conversations with somebody who had a conversation with Mr. Chin? I just want to clarify. 'Cause
Yeah,
you
sure. No, I'm
mentioned-
happy to answer the question if you'd permit me just to speak about how ministers, at least my minister's office works. I have an incredibly close relationship, necessarily so, with my chief of staff. I also at that time had a very close relationship with my judicial affairs advisor, who throughout some of this period of time was acting as my chief of staff, given that we were out of the country. Whenever my chief of staff has a conversation, she takes notes on the conversation and immediately relays the conversation to me, particularly in cases where there's concerns about the conversations that were had. So the close relationship and the necessary closeness of the relationship makes it that she and I are sharing important information and proceeding on the same basis with respect to the meetings, telephone calls, and emails that she would receive. It is her obligation, and it was my instructions for her to provide me with all of these details.
Thank you. And
Ms. O'Connell, your last question.
okay, perfect. Thanks. And then it was in here. I'm sorry, I don't recall, but it did say somewhere in these conversations that either you or your staff related on behalf of you that you would be in this at least September timeframe open to having further conversations on the SNC-Lavalin matter. Is that not correct? Or in September you had felt comfortable and confident that the decision was made?
Well, during that time frame, I had commenced conversations and had asked for briefings, as I regularly did when I received a Section 13 notice. I think it's fair for me to say that there was a heightened awareness about this Section 13 notice that came in with respect to SNC. These conversations were all internal to the Department of Justice, and I was exercising with my Attorney General hat on what was appropriate for me to consider based on what I read in the Section 13 note from the director. We did not reach out externally. The Minister of Finance's office reached out to my department, and then these conversations began.
Thank you.
Thank you. Mr. Rankin.
Well, thank you. Mr. Chair, I have to say that I am very shaken by what I've heard here today. I've been a lawyer for over 40 years. I've taught a generation of law students about the rule of law. And what I've heard today should make all Canadians extremely upset. Now, Ms. Wilson-Raybould, we're both from British Columbia. We've known each other for many years, and I need you to know that I believe you entirely. I need you to know that. And I want you to know as well that I very much admire your courage in being here and telling Canadians what you have experienced. Because I believe, if we believe you, which I do, that there is no other conclusion that one can reasonably draw, but that there was a sustained, consistent effort to interfere politically with the critical role that an Attorney General must play in our legal system. You have said, to quote back what you said, I experienced a consistent and sustained effort by many people within the government to seek to politically interfere in the exercise of prosecutorial discretion in my role as the Attorney General of Canada in an inappropriate effort to secure a deferred prosecution agreement. You talked of 10 phone calls, 10 meetings specifically about that. And then you talked about what I would call the consequences and threats if you didn't knuckle under. You said the potential for consequences and veiled threat if a deferred prosecution was not available to the SNC were brought to your attention during those conversations. So my question is this: how can Canadians, if they believe you, as I do, draw any other conclusion but that there was an attempt to politically interfere with your role as our independent Attorney General?
Well, thank you for the comments and the question, albeit I think the question is somewhat rhetorical. I sought in my testimony today to state facts. And in my testimony, I came to the conclusion, and throughout the 4 months, that there was a sustained effort, an attempt to politically interfere with my discretion as the Attorney General of Canada. It was inappropriate.
And on January the 11th, you said that the Friday before the cabinet shuffle, your former deputy minister was called by the clerk and told that the shuffle was happening, and that the deputy minister said one of the first conversations that the new minister will be expected to have with the prime minister would be on SNC-Lavalin. So it appears to a reasonable person looking at that you were removed from your role because you would not change your mind, despite these persistent and consistent efforts to have you do so, and that because you didn't change your mind, you were fired from the role of Attorney General. That's what I take from the material. In other words, there appears to be a direct link from that conversation the day before the cabinet shuffle and what occurred, your removal from your role as Attorney General. That would appear to be what's said. Now, I have a question. After this, what you call consistent and sustained pressure to reverse your decision, I'd like you to tell us a little bit more why you did not change your mind.
I did not change my mind to enter into or to issue a directive to the Director of Public Prosecutions on the matter of putting out an invitation to negotiate a remediation agreement with SNC, because I had the benefit of reading the Section 13 note, of conducting my own due diligence around the appropriateness of entering into a deferred prosecution agreement with SNC. I had the benefit of feedback and briefings from my departmental officials as well as my political staff. I made my mind up prior to the September 17th meeting. And for those people that know me, my decision-making process takes into account many views, and I welcome many views on public policy issues. And having taken into account many diverse views, knowing confidently my role, my independent role as the Attorney General, and the need to make a decision, and I know you are studying the Shawcross principles, and I don't want to get into talking about the Shawcross principles, but as the Attorney General, you make decisions with your judicial hat on, leaving aside political considerations or otherwise. I had determined that I was not going to issue a directive. It was inappropriate to interfere with the discretion of the Director of Public Prosecutions, and having made up my mind, taking into account all of the information, again, for those who know me, I was not going to change my mind.
Thank you.
Thank you very much. Ms. O'Connell?
Thank you. Thank you. So following up on some of those timeline questions, I just want to, it looks like in the response you didn't meet again with Jerry until December 5th in terms of raising your specific concerns that you felt this was interference. So just given that how long you've known Mr. Butts, and I believe it's been widely reported he was someone who recruited you, so you had known each other even prior to politics to run for the Liberal Party. I'm just curious if it is fair to say that it wasn't until the December 5th meeting with Mr. Butts, that you hadn't messaged him about your concerns about what you described as constant pressure. If you had communicated with him in any way via text, email, whatnot, prior to that December 5th meeting to say that you felt these conversations needed to stop?
Well, I'm not going to comment on the nature of my relationship with Mr. Butts.
That's fine.
But I will say that it was the Prime Minister, the then leader, that recruited me into the party. And of course, there were ongoing conversations between him and Mr. Butts.
Sorry, can I just say then, is it fair to suggest, though, that you had known him and you were comfortable with him, you had talked to him, I would assume, regularly?
Yeah, of course.
Okay.
I had fairly regular conversations with Jerry. In fact, Jerry said to me many times, and I don't think this is a secret, that I talk to you more than I talk to most ministers, and I appreciated that relationship. To the second part of your question, as I said, there was sustained efforts at communications, not only with myself but with my office, from various members of the Prime Minister's office, including Mathieu Bouchard and Elder Marquez, both of whom are policy advisors and legal advisors to the Prime Minister, as well as to Jerry Butts and Katie Telford. It would have been, in my view, not a secret that these were concerns that I had.
But if it just following up on that, if it wasn't a secret that those were your concerns, why not until December 5th did you communicate with Mr. Butts specifically about those communications? It was somewhat stated that you would be willing to, or someone in your office would look at the matter back in September. So if it was constant, and you acknowledge that you spoke to Mr. Butts on a regular basis, why not raise it earlier in September or October about those ongoing conversations with anyone in the PMO or other ministers' offices? Or did you, I guess is a fair point, did you communicate prior to that about those concerns?
I appreciate the question and being able to clarify again the timeline. I absolutely communicated in September, not to Jerry Butts, but to the Prime Minister of the country, the concern that I had. I communicated to the clerk of the Privy Council, who, as everybody knows, is the Deputy Minister to the Prime Minister. I communicated to Elder Marquez and to Mathieu Bouchard. I communicated to the Deputy Minister of Justice and the Deputy Attorney General of Canada. And when the sustained efforts of political interference continued, I felt, and I have text messages when I requested the meeting with Jerry, that ultimately resulted on December the 5th, that it was time to reiterate my concerns to him about the inappropriate nature of these conversations, as I did to Minister Morneau in October, I believe, or September, I might be getting the dates wrong, about the inappropriateness and that they had to stop.
So then you didn't mention Ms. Telford. So is it fair to say you didn't speak with Ms. Telford, I guess, between those September dates? Or did you ever mention it to Ms. Telford about or have communications via text, emails, and writings that what you say were continued pressure?
Just to correct, it was September the 19th that I had the discussion with Minister Morneau. To your question, most of the conversations that I have with the Prime Minister's office at the highest level, either Katie or Jerry, would be with Jerry Butts.
Okay.
But to be clear, my Chief of Staff had direct conversations with Mr. Butts and Ms. Telford, as I described in detail on December the 18th.
So early, and then after September 19th, that meeting with the Prime Minister, did you speak to him again about the continued pressure that you felt?
The meeting I had with the Prime Minister was on September the 17th. And after September the 17th, I did not directly talk to the Prime Minister until January the 7th. But in between those dates, there were, as I described, numerous meetings with the Prime Minister's office senior staff, as well as the Clerk of the Privy Council.
And you mentioned earlier in my first round that you felt it was entirely appropriate to have the conversation about the jobs and those types of impacts. I'm paraphrasing here, and then you mentioned Minister Morneau and the conversation you referred to on the 19th, which was in the House, I believe you said in the testimony, and you said that he mentioned job losses. So what made you feel that conversation was then inappropriate?
Was inappropriate?
Yes.
So to the first point about mentioning jobs and job losses, as I said in my evidence, including the conversation I had with the Prime Minister, I do not believe it is inappropriate to have conversations about job losses, about SNC in the early stages where ministers can raise these issues with the Attorney General. What is inappropriate is the long sustained discussions about the job losses after it is very clear that I had made my decision and was not going to pursue a DPA. But leaving aside job losses, the conversations that I had where they became very clearly inappropriate was when political issues came up, like the election in Quebec, like losing the election if SNC were to move their headquarters. Conversations like that, conversations like the one I had with the Clerk of the Privy Council, who invoked the Prime Minister's name throughout the entirety of the conversation, spoke to me about the Prime Minister being dug in, spoke to me about his concerns as to what would happen. In my mind, those were veiled threats, and I took them as such. That is entirely inappropriate.
Thank you very much. So now we move to the second round. In the second round, it goes 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So that is round two. We'll start round two with Ms. Sahota.
Thank you, Mr. Chair. So I'd like to first go back to the September 17th meeting with the Prime Minister and the Clerk of the Privy Council. You mentioned that it was here where you had specifically asked the Prime Minister whether he was interfering, and his answer was that the decision was always yours. Is that correct?
That's not exactly what I said. I had raised the background about comments that were made by the Prime Minister and the Clerk, and I know that has been what has been reported in the media, but that's not what was said. I asked the Prime Minister a direct question after having comments around elections and being the member of Papineau. Are you interfering with my role as the Attorney General, my decision? And I advised him strongly not to do that. So it was my direct question to the Prime Minister.
And he said the decision was always yours, correct?
He did not say that. He said, no. That's not what I'm doing.
Okay. But you did mention in your opening statement that throughout the whole time you were Attorney General, you did recognize that the decision was always yours.
I 100% understand my role as the Attorney General, and it is my decision and my decision alone whether or not to issue a directive.
Okay. So this September 17th meeting, you had asked for it earlier in September, and you said at that point you had gone on vacation. And did you receive this request for the meeting quite quickly?
I didn't say that I went on vacation. I was actually down in Australia for a Five Eyes meeting and happened to thankfully have a couple of days off.
Okay.
When another very important issue arose. And I, at that point, had requested directly to Jerry Butts via text message that I wanted to have a one-on-one meeting with the Prime Minister. That was in and around September the 6th.
Okay. And then on September 17th, you received the meeting after you came back into the country.
I got back into the country on September the 12th and was able to meet with the Prime Minister, yes, on September the 17th.
Okay. So the main purpose for this meeting, what was the main purpose of the meeting?
I am not at liberty to discuss that as meetings and discussions between the Prime Minister and myself, other than what's covered in the waiver with respect to SNC and deferred prosecution agreements is covered by Cabinet confidence.
When the clerk of the Privy Council testified here before committee, he had mentioned that the main purpose of that meeting was the Indigenous rights framework, and that SNC-Lavalin was a subject matter that was touched on briefly. Would you be able to say if that was correct or incorrect?
I will say that the clerk of the Privy Council is at liberty to say whatever he wants. I have indicated that the meeting of September the 17th had to do with another extremely important matter, but that the Prime Minister raised the issue of SNC and deferred prosecution agreements at the outset of that meeting.
Okay. My next question is about the fact that you had mentioned the appropriateness or inappropriateness and where the line has kind of been drawn. You've indicated that when talking about jobs, the Prime Minister or the member from Papineau was completely in an appropriate space. But when you said he had spoken about the headquarters moving out of Montreal, that was inappropriate. Is that correct?
No, I didn't say that. I said that where, and I didn't say alarm bells, but where my alarm bells went off was when the clerk of the Privy Council talked about the fact that there was a board meeting for SNC coming up on Thursday, September the 20th, that there was an election in Quebec, and then the Prime Minister interjected and said, I'm a member, or I'm an MP from Quebec, the member for Papineau. That is entirely political and entirely inappropriate, which gave rise to the question that I asked the Prime Minister.
You had mentioned, just in some of your answers to the questions, about him mentioning he's the member from Papineau, correct, that he was talking about the election, and then he had mentioned that if we don't find a solution, the company might move from Montreal. And I mean, in my view, when a company picks up and moves from a city or from a country, that means job losses. Is that not correct?
Well, that's your view. Of course, I was aware of the potential for job losses.
Okay. And that is a legitimate conversation for a Prime Minister to have.
Well, again, at the time, I didn't see it as being entirely inappropriate. Of course, ministers of the Crown can approach the Attorney General and raise public policy concerns about decisions that the Attorney General will make. Where it became inappropriate was the sustained discussions after I had made my decision and made my decision known.
On September 18th, I believe you.
This will be your last question.
Okay, thank you. On September 19th, you had both met with the clerk and you had met with Minister Morneau in the House. In your discussion with Minister Morneau, I believe you had said that it's inappropriate and he should stop talking about it when he had talked about saving jobs. But in your discussion with the clerk on that same day, you had offered that if SNC-Lavalin were to send a letter to you expressing their concerns and their public interest arguments, you were open to looking at that letter. Is that correct?
That's not correct. I did.
It's here in your statement, opening statement.
If you allow me to answer, I can just clarify where that part wasn't correct. I had discussion with the clerk of the Privy Council, recognizing the conversation that I had just the day before had with the Prime Minister, where he asked for solutions, recognizing I had already made my decision. I had indicated to the clerk of the Privy Council that if SNC were to send a letter to me as the Attorney General expressing their concerns, their national interest concerns, their public interest concerns, that if I were to have received a letter, I would have immediately forwarded it on to the Director of Public Prosecutions. I would not have looked at it because it is entirely within the purview of the Director of Public Prosecutions, and any involvement I would have in that letter would be inappropriate. So what I said was I would immediately forward it on to the Director, not consider the letter.
Okay, thank you.
Thank you. Ms. Raitt.
Ms. Wilson-Raybould, when you speak to Jerry Butts or Katie Telford or the clerk of the Privy Council, do you believe that they are speaking with the full authority of the Prime Minister in their discussions with you?
Yes.
I'm wondering some specific questions, if I may. Do you believe that the Prime Minister or anyone in the Prime Minister's office had any lawful authority to tell you to direct the Director of Public Prosecution on what to do?
No, I was the final, and as the Attorney General, is the final decision maker on whether or not, as the top prosecutor, to do anything with respect to a specific prosecution.
Yeah. Is it fair to say that, given your testimony and everything you've told us, that you suffered from repeated communications with you, either directly or indirectly, with the intent of changing your mind? It was repeated communications, directly or indirectly.
That's fair to say.
Okay. I'm wondering as well, given the number of times in the final part of your statement, Mr. Butts indicated to you in your conversation that you needed to find a solution to the issue. The clerk of the Privy Council, in the statement that you received, in the text that you received from your chief of staff, there's details about not wanting to debate legalities anymore. There's no solution that doesn't come from some interference. The clerk indicating that I think he, meaning the Prime Minister, is going to find a way to get it done one way or the other. You reference as well that it's the Prime Minister's prerogative to do what he wants. You said you were having thoughts of the Saturday Night Massacre. The clerk said he was worried about a collision between you and the Prime Minister. You mentioned a few minutes ago that you thought they were veiled threats. This all seems to me, if I may, that there was an intention from all of these comments and this continued pressure to make you fear for your job at the end of the day, that there would be a shuffle or that you would be removed from your position. Is that a fair assumption that I'm making?
Well, I'm not going to speak to the intention of other individuals.
Fair enough.
I will speak to the very heightened level of anxiety that I had that increased and culminated in my discussion with the clerk on December the 19th. And I remember distinctly ending that conversation with the clerk by saying, I am waiting for the other shoe to drop, which I believe that reflection or my comments can speak for themselves.
And I'm not trying to split a hair here, and I apologize if you take it that way and you can give me the same answer as you did on intention. But do you think the purpose of those comments were to cause you to have a second look at the issue because you were worried about whether or not you'd remain in cabinet?
Can you answer the question again?
I certainly can. Do you think the purpose of those comments that were thrown into your conversations, either with you, with your chief of staff, directly with the clerk, through Jerry Butts, through Katie Telford, or even the clerk indicating how anxious the Prime Minister was and you didn't want to be at loggerheads, do you think the purpose of those comments that they threw in their conversations was to put pressure on you and make you think about whether or not you would be remaining in cabinet?
I am confident that the purpose of those discussions, the December 18th and the December 19th discussions, were to put extraordinary pressure on me to change my mind.
Yeah.
As to the intention of the individuals that spoke to either my chief of staff or myself, I can't reflect on their intent.
Yeah, no, fair enough. I have. Okay. If I may, on January 7, you received your phone call that you were going to be moved in positions. I've had that phone call in the past as well, so I know what it's like. But I'm wondering if there was any conversation that you can tell us about in terms of who told you that you were going to be moved from Attorney General to Veterans Affairs, and if there's anything pertinent to SNC in that conversation.
Well, I did state, and this is within the order in council and the waiver that was provided me with respect to cabinet confidence, with respect to SNC and deferred prosecution agreements. I had a conversation with the Prime Minister on January the 7th, and he spoke to me about my being shuffled out as Minister of Justice and Attorney General, provided rationale of which I won't get into. And then I said to him, I can't help but think that this has something to do with a decision I would not take. I had a subsequent, very close in time conversation with Jerry Butts where I specifically said, I know this has to do with SNC and a decision that I wouldn't take. To which he said, are you questioning the integrity of the Prime Minister? To which I didn't say anything.
Thank you.
Thank you very much. We will now go to Mr. Sassi.
Thank you, Mr. Chair. Thank you, Ms. Wilson-Raybould. Good to see you here before committee today. Now, I won't be delving into facts. I will be talking about context, if you will. Now, you recall that in your capacity as Minister of Justice and Attorney General, that remediation agreements were considered and approved by Cabinet. Is that correct?
That is correct.
And you were also a Minister of Justice and Attorney General on June 6th when Parliament voted in favor of Bill C-74, and you yourself voted in favor of Bill C-74. Thank you. Now, you would agree with me that the concept of alternatives to prosecution is not a novel concept in the landscape of various areas of law. For example, in the area of international law, there are guidelines, going back to the 1990s about alternatives to prosecution. We see this quite often when it comes to our own criminal code, when it comes to diverting cases through the Youth Criminal Justice Act. We see it with respect to white-collar crime. Would you agree that it's that this concept has been around for quite some time?
I will say this. We now have in our criminal code tools that are provided to the prosecutors on whether or not to enter into negotiations around deferred prosecution agreements. These are tools that other countries have utilized.
Speaking of other countries, as you noted, and you did reference the Five Eyes, to the best of my understanding, with the exception of New Zealand, the United States has had deferred prosecutions. The United Kingdom has had it. France has a DPA-like mechanism. Australia is in the process of adopting it. So given all these developments, would it be fair to say that many commentators are of the view that we are now leveling the playing field and that we are playing catch-up with those jurisdictions?
Well, I'm not going to comment on what other commentators are saying, and I will say this. I am not going to make further comments on deferred prosecution agreements. I recognize my responsibilities as a member of Parliament, and I recognize that there are two court cases that are currently in play.
So perhaps I understand you don't want to speak to that issue, but you would agree that there were extensive public consultations on the issue.
There were consultations that were conducted in advance of the passage of the legislation.
Yes. Now, I understand in your remarks, you were suggesting that some people were approaching you and asking that you obtain legal counsel. Would it be fair to say, as a routine matter of work, that your department does receive legal advice from various firms?
I'm sorry, could you clarify what
Yes.
you meant by people were approaching me to obtain legal counsel in what context?
Yes, I understand that you referred that there was one discussion with Mr. Bouchard, and he asked you whether you would consider the option of seeking an external legal opinion.
So in the context of deferred prosecution agreements and SNC, yes, I had that conversation with Mathieu Bouchard, Elder Marquez, and a number of other individuals. At that time, all of those individuals knew that I was firm on my decision not to interfere with the discretion of the Director of Public Prosecutions, and having conversations about hiring external legal counsels in that environment is entirely inappropriate.
But you've worked on some very difficult files during the period you were serving as Minister of Justice and Attorney General. Would it be fair to say that routinely you would ask for outside counsel just to have a better understanding of various pieces of legislation?
In my role as the Minister of Justice, and having had the opportunity, as people here know, coming before this committee on various pieces of legislation, we would engage with external counsel. But let me be clear. My role as the Minister of Justice, shepherding legislation through the House of Commons, is entirely separate from my role as the Attorney General. Where suggestions of obtaining external legal counsel after I had made my decision as the Attorney General on this matter, that was entirely inappropriate.
Thank you very much. Last question, Mr. Assassi.
Thank you. Now, before I leave this section, would you mind explaining to us what your misgivings were about DPAs?
I do mind. I'm not going to have that conversation. I think it's inappropriate as a member of Parliament, recognizing that there are two matters before the court.
Thank you very much. Monsieur Paulus?
Merci.
Mr. Paulus, thank you. Thank you, Ms. Wilson-Raybould, for this very important testimony for Canada and for democracy. Before I begin, I just wanted to give Ms. Raitt a few moments.
Ms. Wilson-Raybould, first of all, having heard it all, I have to ask you the question. Going from being your first appointment and going through the last 4 months, and although having comfort going into Veterans Affairs, which is a wonderful portfolio, and I agree with you fully that you served there. How did you feel at the end of this? Like, what's the emotion that you felt out of all of it? I mean, you're giving us wonderful facts, but surely there must be some level of disappointment or sadness out of how everything has unfurled.
Generally, or with respect to being moved as minister?
No, in general, how you've been treated.
I have serious concerns about how things are reported. I have concerns about what people generally call smear campaigns. It makes me very sad when, and this isn't about me personally, it's about the work that I was able to do with an extraordinary group of people when I was the Minister of Justice and the Attorney General, being impugned publicly, recognizing the commitment that my public servants then, and I know to this day, have to ensuring justice in the country and moving forward with legislation, as well as my political staff. So how do I feel? How did I feel? I have to say that I loved being the Minister of Justice and the Attorney General. I can't imagine any lawyer not loving being the Minister of Justice and the Attorney General. And I believe that I served in that role with hard work and with integrity. And I'm proud of the legacy that we left. So I don't want to make anybody think that I wasn't sad when I was shuffled out of that role. Of course I was. But I understand that it's the prerogative of the Prime Minister to make those shuffles. And how I conduct myself is to embrace other opportunities, which I sought to do in the unfortunate limited time that I was the Minister of Veterans Affairs.
Thank you. And my colleague, Pierre Paulus.
Merci. Oui, merci.
Thank you, Mr. Chairman. Ms. Wilson-Raybould, the Minister of National Revenue, Ms. Laboutier, mentioned that this question was raised during a cabinet meeting. In his testimony, Mr. Wernick said it's never been discussed in cabinet. You can't have two different versions. I don't want the details. I just want to know which of these two people is right, Ms. Laboutier or Mr. Wernick.
Well, I'm not going to comment on which of those two people were right, but what I can tell you is what I know, recognizing that I'm able to speak about SNC and deferred prosecution agreements. We had discussions at Cabinet about creating a new tool for prosecutors, remediation agreements. There were conversations, but not central to the conversations. There were peripheral comments about SNC, but it was not the heart of our discussions. Our discussions were about creating the tool for prosecutors.
Okay, merci. Le Premier ministre Trudeau a dit.
Prime Minister Trudeau said that you could talk about information that's relevant on this affair. Do you think there is relevant information that you cannot discuss with us?
I answered a similar question to this one. As I said in the letter and as I said here today, and recognizing some of the questions that members around the table have asked, I have an inability to speak about the time frame between January the 14th, when I was sworn in, through to meetings that I may or may not have had with the Prime Minister, my resignation, and the conversations that obviously has been widely publicized that I had with my former colleagues around the cabinet table. I am not able to speak to those issues.
Thank you. Merci beaucoup. Mr. Rankin, this is the 3-minute time for you.
On February 12th, Madam Wilson-Raybould, the Prime Minister said this, quote, "If anyone felt differently, they had an obligation to raise that with me. No one, including yourself, did that," close quote. But you've testified that you met the Prime Minister on September 17th. You've testified that on December the 5th, Jerry Butts and you got together, and you've told us that he speaks with the full authority of the Prime Minister. On December the 18th, your Chief of Staff had a meeting with Mr. Butts and Ms. Telford. So isn't that, at the very least, a misleading statement by the Prime Minister? You did speak with him. Your people spoke with him. You spoke with his people. Isn't it, in fact, misleading to say you did not do that?
Well, again, I'm not going to speak directly to comments that the Prime Minister made. I believe that the chronology and the facts that I presented here before the committee and the testimony that I've given speaks for itself.
Okay. I'd like your comments on something that was referred to earlier. In your testimony, you said on December the 19th, you had a call with the clerk of the Privy Council office, Mr. Wernick, who testified here before. And referring to the Prime Minister, the clerk said this, quote, your words, "He's going to find a way to get it done one way or the other. So he is in that kind of mood, and I wanted you to be aware of that." What do you understand by those comments?
Well, as I said, I had, during this conversation with the clerk, I had a heightened level of anxiety. Again, this was the culmination of many meetings and telephone calls with either myself or my Chief of Staff that continued to escalate. This was the top of that escalation. And I said there were 3 times in this conversation where I felt that the clerk invoking the Prime Minister's name was acting in a threatening manner.
Do I have another? All right. You've told us, and the Order in Council precludes us from talking about things after January 14th. Apparently, that's the rules. We can't talk about that. But on February the 18th, Jerry Butts, the senior advisor to the Prime Minister, resigned. We had all these meetings about SNC Lavalin. In his letter of resignation, he referred specifically to you. Do you know why?
I have absolutely no knowledge other than what everybody has read in the statement by Jerry Butts, why he resigned, if there was any other reason.
Thank you.
Thank you very much, Mr. Rankin. That concludes the second round. We now have already agreed that we're going to do a third round. So just for Ms. May had mentioned this to me, and I saw Mr. Fortin putting up his hand. What the committee has done in the past is in the very last round of questions, when we realized we were in our last round, we've asked for consent for the Bloc Québécois that was here to ask a question. When we get to what the committee agrees is its last round of questions, I will ask the committee members at the end if they agree to that, and that's where we'll go. But we won't do it each and every round. So we're now in our third round. The third round is 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. Ms. Raitt.
Given the testimony that you provided for us today, Ms. Wilson-Raybould, I have to ask the question about whether or not you were approached by the Prime Minister, the Prime Minister's office, the Clerk of the Privy Council, and given any directions, directives, or suggestions on the conduct of the Mark Norman trial or any other trial that was within your bailiwick as the Attorney General.
I'm not at liberty due to confidences to discuss any matters beyond SNC and deferred prosecution agreements.
Thank you. And for clarity, can you tell us what you discussed with the Prime Minister at your meetings in Vancouver on February 11th?
I cannot.
And can you tell us why you've resigned from Cabinet?
I cannot.
And can you tell us what was discussed with the Cabinet on February 19th?
I cannot.
If the issues surrounding your ability to communicate these conversations to this committee were in fact resolved and you were able to be released from cabinet confidence or from privilege, would you be willing to return to this committee and give us testimony again?
I would be.
I'm wondering as well, Ms. Wilson-Raybould, that when the clerk was speaking with you in those communications, I know I've asked you already, but I want to just be crystal clear that when the clerk was speaking with you, he was speaking with the full weight and the authority of the Prime Minister, and it was your understanding that the Prime Minister was speaking through the clerk to you.
I can only go by what the clerk said to me in those conversations. In that conversation where he invoked the Prime Minister in terms of relaying messages from the Prime Minister.
Okay. And if I may clarify, in your statement, you have delineated these for us in terms of going through what the things that the clerk was saying on behalf of the Prime Minister. It's contained in your statement before us today.
That's correct.
Okay. A couple of times you have mentioned about your January 7 phone call with the Prime Minister about not going to be the Attorney General any longer. And you've indicated a couple of times that you didn't want to talk about what the contents of the conversation were. I respect that. I'm not going to ask you a third time. Can you tell us why? Under what authority are you saying that you don't want to disclose the conversation, just so that I can understand whether or not you were bound by something else, so that we can perhaps take that roadblock out of the way to get your full testimony?
Well, I'm not going to provide legal advice to the committee, but I am going by the order in council and the waiver that was provided around SNC and deferred prosecution agreements, and any conversations around those topics when I was the Attorney General I am able to speak about.
Your Chief of Staff, her name is Jessica Prince, correct?
That's correct.
Was
former
she
chief of staff.
I'm sorry, my apologies. Correct. Your former chief. I understand fully the relationship between chief of staff and minister, and it was pretty awesome that she decided to move with you to Veterans Affairs. Just saying, it's very nice.
I thought it was totally awesome.
Yeah, very awesome. What I would like to know, though, is in her conversations with Ms. Telford and Mr. Butts, did she indicate to you, and I know it's hearsay, but you do have testimony talking about her text to you, did she have fear about whether or not she would still have a job as a chief of staff if she didn't convince you to review the decision on interfering with the trial that was ongoing?
I, of course, don't want to speak for Jessica on this, about the specific question on fear.
Yeah.
I can say that in my conversations with her and in my text messages, but particularly in my conversations with her after that, she was quite upset after the meeting. And I will say now that I have this opportunity, and I think some people are watching, to Jessica Prince, who was my chief of staff at the Department of Justice and came with me to Veterans Affairs. She is an extraordinary human being and an extraordinary lawyer.
Incredibly well educated and very professional in everything she does. I would agree with you on that, and I think everyone will appreciate that you give kind thoughts to your chief of staff. That's always extremely nice. One last thing, if I may. Can you remind us that, well, it's my understanding, and it was in the case when we served, that chiefs of staff are hired and fired essentially by the Prime Minister's office at the end of the day? It'd be difficult for you as a minister to retain a chief of staff that was not in favor with the Prime Minister's office. Is that true in your case?
I'm not going to comment on the interactions between my office and the Prime Minister's office.
Okay, thank you. Thank you.
Very much, Ms. Raitt. Ms. Khaled.
Thank you, Chair, and thank you, Ms. Wilson-Raybould, for appearing today and sharing with us your viewpoints on this. I've always felt that you've been a very vocal advocate on issues that you genuinely believe in, without regard to other viewpoints. You've been vocal at Cabinet, you've been vocal to the Prime Minister, you've been vocal to Canadians. In fact, you've gone on the record at many public events and you've really expressed your viewpoints on issues that you genuinely believe in, such as the Indigenous file. And I just going through your testimony and your chain of events, I see that there hasn't been communication between you and the Prime Minister himself from September up until the time when he called you for the shuffle. Why is that? Why didn't you speak out to the Prime Minister when you've been so vocal on issues such as the Indigenous file, and you know that you have the access? Why did you not speak out to him when you had these concerns? And do you feel that you had an obligation to do so?
Well, I need to say a couple of things with respect to your question. I completely reject your characterization of that I do not have regard for other people's opinions. And you talked about the Cabinet table. And with respect, you would have no ability to know about discussions around the Cabinet table. I don't apologize for being vocal with my opinions. That doesn't mean to say that I don't value other people's opinions, because for the entirety of my professional career and how I was raised, in terms of consensus-based decision-making, it is incredibly important to take into account the views of other people. That's how we make good public policy in this country. You talk about Indigenous issues. I'm a proud Indigenous person from the west coast of British Columbia, and I will not apologize for being a strong advocate pursuing transformative change for Indigenous peoples in this country. I have worked in the Indigenous world as a politician for a significant amount of time and have a very in-depth understanding of the issues that Indigenous peoples face. That's not to say everybody agrees.
Ms. Wilson
And I
Raybould.
appreciate to hear other people's opinions. And to your question with respect to the Prime Minister, I believe I've covered that ground. I had a direct conversation with the Prime Minister as I had direct conversations with the people in his office and the Clerk of the Privy Council.
Please excuse me, Ms. Wilson-Raybould. I was referring to your vocal advocacy as a sign of strength. You know, as a member of Parliament and your colleague, having worked with you, I acknowledge your effectiveness in advocating for the issues that you genuinely believe in, and we appreciate that. Thank you for your service. I do want to just understand here. You mentioned the political interference being cited as the Quebec election. And the Quebec election was over at the beginning of October. So if you can please help Canadians understand, from October to December, what was the context of the inappropriate pressure?
Sure. Yes, the Quebec election was something that was brought up on the September the 17th meeting. There were many other inappropriate conversations and attempts at political interference that occurred after that date. An example, which I've already talked about, was after I had made my decision as the Attorney General, which is entirely within my discretion to make. There were repeated attempts by people in the Prime Minister's office to get me to hire external legal counsel to evaluate my decision. There were further conversations about the election coming up, and if SNC were to move, this would be detrimental to the election. I further said that when we're talking about jobs and job losses, and of course I don't think there's anybody around this table that doesn't want to prevent job losses, that it was appropriate in the initial phases. But after I had made my decision as the Attorney General not to enter into or issue a directive, the successive and sustained comments around jobs became inappropriate because I had made my decision and everybody was fully aware that I had made my decision. I believe where it got even more heightened were what I described as the veiled threats that came towards the latter part of this time frame around December the 18th and December the 19th. There were many different occasions where the appropriateness line was crossed.
So just to clarify, thank you. Just to clarify, Ms. Wilson-Raybould, all right. So from after the Quebec election up until the end of December, as per what you've just said, are you stating, and I'm just seeking clarity here, are you saying that it was inappropriate because you had expressed that your mind had already been made on this issue?
My decision not to issue a directive had occurred prior to the September 17th meeting. The Quebec election, any partisan considerations before or after are entirely inappropriate, not relevant to me at the time wearing my judicial hat as the Attorney General in terms of considerations about whether or not I was going to exercise my discretion and issue a directive.
Thank you very much.
Thank you.
Mr. Rankin.
Thank you. Just a technical question at the front end, Ms. Wilson-Raybould. I wonder if you could provide the committee with a copy of all the text messages and emails that you referred to in your testimony?
I hear the question. I'll take it under advisement.
Thank you. You were, in referring to your conversation with Mr. Wernick, the top public servant in the country, the clerk of the Privy Council, in an answer to a question, you said something about waiting for the other shoe to drop. What did you mean by that?
Well, as I said before in questions, this was a very tense conversation. I had a high level of anxiety. This was the combination, or the culmination rather, of many phone calls and face-to-face meetings. What I meant by I was waiting for the other shoe to drop. At the end of the conversation, that's how we closed out our telephone call, was that I was under the understanding, based on what the clerk had told me, that he was going back to talk to the Prime Minister before he left, recognizing what he had also told me, that the Prime Minister was dug in, that he was firm, that it's not a good space to have an Attorney General at loggerheads with the Prime Minister. I had a heightened level of anxiety that I would be getting either a call from the Prime Minister the next day, which the clerk indicated might happen, and that there may be further direction or another outcome for me as the Minister of Justice and Attorney General.
In other words, consequences for you doing your job as an independent AG and saying you'd made your decision up, that was it. There could be consequences, is what you inferred from that conversation.
That is a fair assessment of how I interpreted the conversation.
Now, you've told us about a lot of officials in the Prime Minister's office, a senior clerk of the Privy Council. Do you not think that Canadians, because we're doing our job for Canadians to get to the bottom of this, that we would have a better understanding of the situation if we heard from the officials that you've referred to?
Well, I can't speak to whether or not you have a better understanding. I believe that it is important to hear from as many individuals that have direct connections or interactions in this case, which is why I don't know if pleased is the word, but I'm fine to be here and having this conversation because I know that it is important for me to put the facts before this committee for your consideration.
Thank you. You said, wrote something very interesting in your remarks, and I'd like to read it to you. You said, the history of Crown Indigenous relations in this country includes a history of the rule of law not being respected. Did this, in your history, your experience that you've referred to, did this inform or strengthen your resistance to any potential perversion of the rule of law, that history to which you referred?
My lived experience is incredibly important for my background, my upbringing, how I think about the world. It's that lived experience, not only as a professional, but being rooted in my Kwakwaka'wakw culture and the values that I was taught by my father and mother and my grandmother, that brought me to my role as the Minister of Justice and Attorney General of Canada. And I believed, and I still believe today, that it is incredibly important to have a diversity of perspectives and background, and to have a country, and we live in the greatest country in the world, that respects every individual with a recognition of the need for equality, of the need for justice, and in the case of Indigenous peoples, that we continue to work hard to create the space for Indigenous peoples to find their place and see themselves in the mirror of our Constitution.
Well, I understand that my time is almost at an end, and I just want to sincerely thank you. I want to thank you because you've presented a list of facts that I believe a reasonable person listening to this, and believing you as I do, would have to conclude demonstrate a sustained pattern of political pressure and interference with the independent role that you swore an oath to fulfill. And I cannot but think that we have more work to do as a result of your testimony. So I thank you sincerely, not just on my behalf, not just on our behalf, but on behalf of Canada, for your courage in being here and telling us what happened. Thank you.
Next, we go to Mr. Bossino. Mr. Bossino.
Thank you very much, Mr. Chair and Ms. Wilson-Raybould. I really appreciate that you're here today. You and I have worked on a number of files together on a number of projects, and so I want to acknowledge your land acknowledgement as well. And if I were back in Treaty 6 territory, might say something like Mio Tatakwin Tatawa, which is Cree for guests, you're welcome, there's room here. So I appreciate what you've done. And that reconciliation and reconciliation with Indigenous peoples is all of our responsibility and the responsibility of all Canadians. I just want to ask a question because we all have our different ways of working, and I think it's known to people who've worked with you that you're a texter, and so I just want to know
I'm a what? Sorry?
You like texts. You communicate well by texting. And did you ever express any concerns to Jerry Butts in writing via text message when you were Attorney General? Were there any concerns expressed to him at all about this matter?
I would have to check, but I can't think of one off the top of my head.
Okay. Did you ever speak or write with Miss Katie Telford at all about the issue of SNC Lavalin or other issues while you were AG?
Yes.
Did you ever speak about the issue of SNC Lavalin, particularly with Miss Telford?
Not that I recall.
Thank you very much. Now, you see the Prime Minister regularly. You're in the House daily, there are cabinet meetings, there are committee meetings, cabinet room, caucus, other meetings, other events. You've talked about the September 17th meeting, and I have your document here, and I appreciate that you've provided a written document for us here. That meeting was with the clerk and the Prime Minister. My question for you is this: as Attorney General, and given all of the interactions that you detailed on that morning that played out over the course that you detailed with us this afternoon, everything that played out over September, October, November, and December, including the meeting with Ms. Prince, did you not have an obligation to raise these concerns with the Prime Minister, to call him or write him or stick up for your personnel or indicate that you felt that inappropriate pressure was being applied?
So I did raise the inappropriateness of the conversations. I raised it with many individuals within the Prime Minister's office. I raised it with the Prime Minister on January the 7th. Let me say this. And again, I am confident and know my role as the Attorney General, and I know and understand that I am the final decision maker on this. Mm-hmm. When faced with sustained pressure from attempts at interference from September the 17th up to and including December the 19th by the Prime Minister's office, by the Clerk of the Privy Council, by the Clerk of the Privy Council invoking the Prime Minister's name, I had concerns. Well, I had beyond concerns. Why would I go to the Prime Minister to raise these concerns when I knew for certain that the DPA with SNC would not occur because I am the final decision maker? And
I'll get
other
back to that issue of final
in the
decision
Prime
making.
Minister's office that were putting pressure on me to change that, included by virtue of the conversation with the clerk, the Prime Minister.
So I appreciate that. January 14th, you accepted a new appointment to Cabinet as the Minister of Veterans. And you know what it's like in caucus. There are people, people run, they want to be MPs, and people want to serve around the big table. And that's part of being in this role. And it's a great honor to serve as a minister in any portfolio. And I can't imagine the great honor that it would be to serve the people who've served this country and who now live after having served. And so after you reaffirmed, on that day, accepting that position, you reaffirmed your confidence in the government. Is that the case?
I was incredibly honored to be the Minister of Veterans Affairs. It was a very different position from the one I had, but I embraced it, and I had a lot of considerations to make on a personal level over the time of Christmas and into the new year, and I'm getting to answer your question. I had serious concerns, as I said, that if I was no longer the Attorney General, that there would be a deferred prosecution agreement entered into and that it would be posted in the Gazette. As I said, I would have resigned from Cabinet at that time. I decided, a very conscious decision, to take on the role that the Prime Minister offered me. And yes, it is an incredible honor. I don't want anybody to misconstrue that. I decided that I would take the Prime Minister at his word. I trusted him. I had confidence in him. And so I decided to continue on around the Cabinet table with the concerns that I had around SNC because I took the Prime Minister at his word.
Thank you. So that oath that you took today, that oath that you took on January 14th, reaffirmed your confidence in the government. Do you have confidence in the Prime Minister today?
I'll say this, and I'm not going to get into any conversations about why I resigned. I resigned, other than to say this, I resigned from Cabinet because I did not have confidence to sit around the table, the Cabinet table. That's why I resigned.
My question wouldn't be why you did resign. My question would be, why didn't you resign before?
Folks, we are now, we've completed 3 rounds. Do we have people that wish to go to a 4th round? Yes. Yes. So we will go to a 4th round. Would the witness like a break, a bathroom break? Or
I don't even know what time it is, so.
I can tell you it's 5:53. Would you like a break, Ms. Wilson?
No, I'm good.
You're good? Okay. So the 4th round, just so that I have it correct, starts with 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So, Mr. Boissonneau, are you continuing? I am. Mr. Boissonneau.
Mr. Chair? I would be happy to. So, okay, it's going to go red. Okay. So, Ms. Wilson-Raybould, you know that I come at these things from a non-legal perspective. I was in business before this, and I'm learning what it's like to be on the Justice Committee. And so it often leads me to seek to understand certain legal principles. And so we've heard here today, and in testimony from other witnesses, including Wendy Berman, Kenneth Jull, and the Clerk of the Privy Council, that the AG has a role to play in remediation agreements. And you mentioned in your document here the concept of prosecutorial discretion. And one of the duties of a prosecutor is to determine whether to prosecute or not, correct? Okay. So from the Public Prosecution Service of Canada handbook, which is available on the Justice Department website if anybody wants to look at it, it says very clearly, when deciding whether to initiate and conduct a prosecution, counsel must consider 2 issues. Is there a reasonable prospect of conviction based on evidence that is likely to be available at the trial? And if there is, 2, would a prosecution best serve the public interest? So with this in mind, would you agree that the 2 questions for a prosecutor are reasonable prospect of conviction and public interest?
Those are definitely questions that the prosecutors take into account.
Okay, so then to go back to the handbook, on the basis of the available material, Crown Counsel must continually assess at each stage of the process whether the prosecution is in the public interest. So I look at this from outside of the legal community, and with the need to continually assess in mind, wouldn't it be fair to say that a decision to continue with the prosecution is never final and is subject to reevaluation in the light of the reasonable prospect of conviction in the public interest? So the AG should have an open mind to new information coming in all the time, and really the decision is never final because it's still active. Like, you have to continually assess new facts and new information. Is that not the case?
Are we talking broadly, or are we talking with specifically to SNC and the DPA?
Well, broadly first, and then I'll get to SNC Lavalin.
Well, I recognize that it is entirely within the prosecutor's ability and discretion to continue to evaluate prosecutions. I was a prosecutor proudly for almost 4 years.
Okay, thank you very much. So then I also saw that in the Justice Department material, issued last year in September that a goal of remediation agreements, one of the goals is to reduce harm that a criminal conviction of an organization could have for employees, shareholders, and other third parties who did not take part in the offense. So if we then look at the criminal code, section 71531 sub F, it says that a remediation agreement is to, quote, reduce the negative consequences of the wrongdoing for persons, employees, customers, pensioners, and others who did not engage in the wrongdoing while holding responsible those individuals who did engage in that wrongdoing. So I think it's fair to say that with the extent of the company, its history, the fact that it employs almost 9,000 people in the country, 52,000 globally, there's a local impact on the communities, home to many innocent pensioners, suppliers, and customers. In your consultation, you said you did a due diligence. How did you take into account the public interest and the impact on the thousands of innocent employers, pensioners, and suppliers if a DPA would not be entertained?
So, Mr. Chair, I believe we're treading on dangerous ground here. I fundamentally uphold my responsibility as a member of Parliament in the sub judice rule, and do not feel it's appropriate, one, for me to answer questions with respect to remediation agreements, the criminal code, or in relation to SNC and DPAs. I believe that's the nature of the question, and I think that members of this committee should tread lightly on interfering with active cases before the court.
Mr. Chair, I appreciate the warning, but Ms. Wilson-Raybould, my question is about the public interest. It's not about a particular matter, and the clerk and perhaps the chair can clarify the sub judice matter. But how could an AG make a decision, and in your words, have a final decision without taking this information into account? It's clearly in the public interest.
Again, and I would appreciate some comments from the chair on this, but I will say, and it's entirely appropriate, and I said it in my testimony, as the Attorney General, all Attorney Generals get Section 13 notices from the Director of Public Prosecutions. The contents of that notice are between the Director of Public Prosecutions and the Attorney General of Canada. I will not go into talking about any of the situations, scenarios, conversations about the national interest with respect to SNC-Lavalin, and I would appreciate hearing from the chair on this.
Thank you very much. So what I would suggest is to keep it to general or a hypothetical of a situation and not to deal with the SNC question specifically as to her decisions on SNC. That's my suggestion. Members, of course, have the absolute right to ask questions here. The witness has the absolute right to answer or not answer based on her own inclinations. And then the committee, should they decide that they want to ask her to answer regardless, has that power. So my request is to try to keep it general or hypothetical to the extent you can.
I appreciate that. Let me ask this question then. What legal doctrine or what legal principles led you to the conclusion that the conversations that you were having with members of the PMO and other colleagues had, in your words, constituted inappropriate pressure? On what basis did you make that assertion? What legal basis? Because we heard from legal scholars that the bar is really high and the bar is very close to direction, and having a conversation, a robust conversation about the public interest or about saving 9,000 jobs or 52,000 jobs is completely legitimate and appropriate conversation. So what's the legal basis on which, what's the doctrine you used to say that your decision was final and you were done taking in new information?
Well, I appreciate the question, and I can reiterate what I've said earlier. I recognize that when I was the Attorney General, and certainly Attorney Generals before me and after, it's entirely appropriate to consider discussions around the public interest. And I had discussions with colleagues with respect to SNC and deferred prosecution agreements about the potential losses of jobs, the potential of SNC moving, but having taken into account everything that I did when I was the Attorney General, including having conversations with my department, my minister's office staff, and doing my own due diligence, I had made my decision that I was not going to exercise my discretion and issue a directive, either a directive under Section 10 or under Section 15, and take over the prosecution because I believed it was inappropriate to do so, recognizing that the Director of Public Prosecutions had made their decision.
Thank you very much. We're
Thank
going to
you.
go to Ms. Raitt.
Thank you. Just back on the directives for a second. Ms. Wilson-Raybould, my understanding from taking a look at reports, these directives are very rare in practice. I mean, I think there have been 3 substantive ones in the past 13 years, 2 from yourself, one on HIV positive prosecutions, one on, I believe, on Indigenous prosecutions as well. I think that was recent, but it didn't make it onto the list. And one from our government on terrorism. Other than that, my recollection is that there really aren't any other directives of a significant heft on policy.
So if I may,
Yes, please.
Yes, there was a directive around, I can't remember the exact thing,
Yeah.
around terrorism.
Yeah.
There was a directive that I issued and was pleased to work with the member, Mr. Boissonneau, on the HIV directive, which I had to follow the process that's outlined.
Yes.
It was a general directive, as the terrorism one was, to provide guidelines to the public prosecutor. In issuing that directive, I had to follow procedures, including putting the directive into the Gazette. Prior to that, I had conversations with the Director of Public Prosecutions, Kathleen Roussel, about the HIV directive, as is entirely appropriate. So that directive came in early December. The other directive, I believe you're referring to the Indigenous Litigation Directive. This was not something that I issued through the gazetting process. This was a directive, an internal directive that I am really happy to have issued internally within the Department of Justice in terms of Indigenous litigation. This did not go through the gazetting process because it was a directive to the litigators in the Department of Justice.
That helps me very much. Now I know why it's on the list, so that's good. But rare. These things are rare. They're very unique and special.
They are very rare. That's not to say that it's not a tool that an attorney general can utilize. General directives, the 2 that we've spoken about, have been issued, but there has never been a specific directive issued on a particular case before the courts, nor has there ever been utilized under Section 15 an attorney general taking over the prosecution.
Yeah.
It is and would be a first if that were to happen.
Extraordinary. Extraordinary. Thank you. I have a question about some testimony that the clerk of the Privy Council gave to this committee. I'm a little troubled by an inconsistency. I'll be honest, and I just wanted to get your take on this. And it's not that difficult. It's not he said, she said this time. The clerk of the committee told us that he learned that a deferred prosecution agreement was not going to be offered to SNC-Lavalin sometime after September 17th, sometime in the fall, he said, and he learned about it through a National News Watch story. Now, your testimony here tells me that he was sitting in the room for the meeting where the Prime Minister brought up the deferred prosecution agreement. Is that your recollection, that he was in the room September 17th and would have known that SNC-Lavalin had been told by that point that they were not getting a deferred prosecution agreement because he was part of the conversation around that topic?
The clerk of the Privy Council would have known on the September 17th meeting because I specifically mentioned it to both he and the Prime Minister, going into detail about the Section 13 notice that I received, and again, I was very clear that I had already made my decision around the deferred prosecution agreement and not intervening.
Thank you. And this committee is here to study a number of issues and to probe the conversations that you had. Committees by nature tend to send reports to Parliament as a result of their study. I'm wondering if you would have any recommendations for this committee for their report in order to help into the future. And I'm not getting into any specifics, just having gone through what you've gone through, anything that you think we should be reporting into Parliament, that would be helpful to our colleagues.
Well, now that you mention it, I mean, I think this is a very serious question, and I'm going to try and give you, well, I'm not going to try, I'm going to give you a serious answer, and I've thought about this a lot. I hope that the committee takes into, to your previous question, as much information and evidence as you can. I appreciate the study on remediation agreements, talking about a relatively old doctrine, the Shawcross Doctrine. I would think it would be a very useful study for this committee to look at the role of the Minister of Justice and the Attorney General of Canada and whether or not those two roles should be bifurcated. I believe, and I have believed this for some time, even before I became the Attorney General, that our country would benefit from a detailed study and consideration around having the Attorney General not sit around the cabinet table like they have in the United Kingdom.
Okay, thank you. Is that it?
You have 10 seconds.
That would be it. You can take a breath. Have a drink of water.
Thank you very much.
Thank
Ms.
you.
O'Connell.
Thank you, Mr. Chair. Thank you again. I want to speak a little bit about the Privy Council Clerk, Mr. Wernick, his testimony. And he spoke about the Shawcross issue. And in some of his testimony, I'm paraphrasing, but I'm sure we could pull up if you want the exact text. But he talked about Shawcross in the context of there's always conversations. I think you even acknowledge that there are legitimate conversations to be had for consideration. And Mr. Wernick pointed out, and part of Shawcross, which I think is relevant here, and I'm going to quote, "In order so to inform himself, he," in this day and age, it's also she, "may, although I do not think he/she is obligated to consult with any of his colleagues in the government, and indeed, as Lord Simon once said, he would in some cases be a fool if he did not," end quote. So that's referring to Shawcross and what Mr. Wernick said. In your testimony today, you mentioned that on September 16th, when there was meetings with your chief of staff or a phone call with Mr. Bouchard and Marquez, the comments were, and you put it in quotes, "We think we should get some outside advice on this." Then on, again referring to your testimony, October 18th, it was also Mr. Bouchard who spoke to your chief of staff and asked if we could get the option of seeking external legal opinion on the DPP's decision not to extend an invitation. Referring back to September 16th, because I heard your testimony that you said you had made up your mind on the issue and that you were not going to intervene. However, in that September 16th commentary that you provided, it was expressed that they said they understood the individual Crown prosecutor wants to negotiate an agreement, but the director does not. So that somewhat indicates to me that even within the prosecution side, there was debate. There was debate on whether or not this was appropriate. And then, so is it unreasonable then, if there's even still debate within the Crown Prosecutor's office or whomever they are referring to there, is it unreasonable then to bring out other advice, which was asked for on September 16th as well as October 18th, to see what legal options there were, since there was clearly within, whether it was with yourself, your office, the Prime Minister's office, within the prosecution, there seemed to be disagreements or differences of opinions, let's put it that way, why would it have been unreasonable? And then referring back to the Wernick testimony and Shawcross in saying that you would want to consult as much as possible on these types of matters. So if there were still some differences of opinions, what would the objection be to bringing in another opinion, an outside legal opinion?
Well, I think I'm fine with it. We're going over very similar ground here. But I had made my decision as the Attorney General. I did not need external legal counsel. I did not need people in the Prime Minister's office continue to suggest that I needed external legal counsel. That's inappropriate. But I will say, with respect to the conversations that you mentioned with Mathieu Bouchard and his remarks about an individual prosecutor as being different from that of the Director of Public Prosecutions, I can't help but wonder why he would bring that up, how he would know that, how he garnered that information. It is entirely inappropriate for any member of the Prime Minister's office, and it would be entirely inappropriate for any member of my staff or within my department to reflect those conversations, because I would have serious concerns, and I did at the time and still do, concerns about how that information was acquired and from whom.
Thank you. So if you felt that information was so inappropriate September 16th, did you consider resigning? Like, if it's moving forward and they continue, did you not consider resigning then?
I did not consider resigning then. I was, in my opinion, doing my job as the Attorney General. I was protecting a fundamental constitutional principle of prosecutorial independence and the independence of our judiciary. That's my job. That was my job, rather, as the Attorney General. And as long as I was the Attorney General, I was going to ensure that the independence of the Director of Public Prosecutions in the exercise of their discretion was not interfered with.
Do you still have confidence in the Prime Minister today?
I'm not sure how that question is relevant.
Okay.
Thank you very much. We will now go to Mr. Paulus. But Mr. Paulus, Mr. Cooper has asked me to give him the last 3 minutes of this 5 minutes, so I'm going to tell you at 2 that we're going to Mr. Cooper.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chairman. Ms. Wilson-Raybould, on December 19th, when you received the call from the Clerk of the Privy Council, Mr. Wernick, the highest public servant in the land, he said, and I quote, he wanted to give you context on this issue. How did you feel about that?
Well, I believe that the clerk also made similar comments when he was before the Justice Committee. As the Attorney General at that point, after 4 months of these conversations, well, actually not even after 4 months, after making my decision, I was entirely comfortable that I had the appropriate context in which to make my decision. I did not, as the Attorney General, live in a vacuum. I have the ability to engage in, read papers, have discussions about the reality of SNC and deferred prosecution agreements. Of course, I was sitting around the cabinet table. I didn't need any context. I certainly didn't need context about the exact same context that I was provided for or in 4 months previous to that.
Est-ce que vous avez considéré que c'était une forme?
Did you feel that this was an interference in justice? An obstruction of justice?
It wasn't an interference because I never let it happen. There was, and let's be clear about that, there was a concerted and sustained effort to attempt to politically interfere with my role as the Attorney General. As the Attorney General, I did not let that happen.
Merci, Madame.
Thank you, Madam.
Much, Ms. Wilson-Raybould, and it's a sad day. and I thank you very much for your candor here at committee. Going to the Clerk of Privy Council, the call that you had on December 19th, was it typical to receive a call with the Clerk of Privy Council? Did that happen often?
The answer is no. But I can't, and I could endeavor to think further about this. It's not that I haven't had conversations with the Clerk of the Privy Council one-on-one. I did have a conversation with him on September the 19th one-on-one in my office. I have known the clerk for many years, and throughout the course of my being a minister, we have had the opportunity to have conversations, but a direct conversation or a direct meeting is something that wasn't very regular.
Right. Well, thank you for that. And in your opening statement, you characterized the meeting by stating that, quote, I was having thoughts of the Saturday Night Massacre. Can you elaborate on that?
Well, I'll give a bit of a Wikipedia version of the Saturday Night Massacre, and perhaps people know what that is. So the Saturday Night Massacre is something that's commonly referenced in and around former President Richard Nixon, when he, in the early 70s, asked his then Attorney General to dispense of a special prosecutor. The Attorney General said no and resigned. The then president, then asked his Deputy Attorney General to do the same thing, and that person resigned. So it's commonly referred to as the Saturday Night Massacre. Anybody can look it up. So I, having said that to the clerk, obviously was having thoughts about what was happening, the potential for direction. Is that right? The potential for direction coming to me from the Prime Minister, and my having to consider resigning.
So it was certainly a little more than...
Last question.
It was, well, I was just going to make a comment. It was a little more than the clerk just checking in with you, as he characterized it.
The clerk was checking in with me on SNC and deferred prosecution agreements.
Thank you very much. We now go to the NDP 3 minutes. Mr. Angus, are you going to do this? Mr. Angus.
Thank you, Mr. Chair. Thank you, Ms. Wilson-Raybould. And I'm actually very honored to be sitting at this table today because what I feel we've witnessed is not politics. We've witnessed a lesson in integrity. I think that the testimony that you gave today will be studied in schools for decades to come, and Canada will be a better place for it. Because the greatest thing we can ask of any public official is to speak truth to power. And I really noticed that in your resignation statement. So I have a very short period of questions. I just want to make sure I understand the frame correct, because it seems what we heard today is a sustained and constant attempt by very powerful actors in the Prime Minister's office who are obligated to uphold justice and the rule of law, yet attempted to interfere with the practice of the rule of law. Would that be a correct assumption from the testimony that you've provided to us?
Thanks for the comments and the question. Again, I know that there was a consistent and sustained effort to attempt to politically interfere with my role as the Attorney General. And I really want to say this, and I'll be brief. I do not want members of this committee or Canadians to think that the integrity of our institutions has somehow evaporated. The integrity of our justice system, the integrity of the Director of Public Prosecutions and prosecutors is intact. So I don't want to create fear that that's not the case. It is incumbent upon all of us to uphold our institutions and to uphold the rule of law. And that's why I'm here.
Well, I thank you for that, because I was really shocked when I read the testimony that you provided recording for Mr. Warnick, the Clerk of the Privy Council, who is obligated to be the nonpartisan voice of the civil service. And he said, I think that would be the Prime Minister, is going to find a way to get this done one way or another. He's in that kind of mood. I want you to be aware of that. And then you referenced the Richard Nixon firing of the special prosecutor as a side issue. But would you take from that, he's in that kind of mood, and I want you to be aware of that you were being given a direct threat regarding the Prime Minister?
I believe that there were 3 occasions in that conversation where there was a veiled threat.
Okay, thank you. I know I only have a few seconds left, but I've heard my colleagues in the Liberals today say, why didn't you resign? Why didn't you raise this as though it was your responsibility? And then why did you not get outside advice to help you change your mind? I'm really pleased that you say that these were attempts to obstruct and to interfere with justice, but the justice system is intact. My question to you is, are you worried that the Prime Minister's office was seeing the role of the Justice Minister as a figurehead that could be moved around, could be changed or interfered with based on the partisan or political needs of the moment?
I'm not going to speculate on considerations in the Prime Minister's office or opinions.
Fair enough. I just want to say, Mr. Chair, I want to move a motion.
Mr. Angus,
that
you've
the
exhausted
committee
your time.
calls on the
Mr.
Prime
Angus, you've
Minister.
exhausted your time. You don't have the
I'm
floor.
moving a motion.
I think I had passed on. What?
Sorry, I'm moving a motion, Chair.
I had not. Okay, so I had at that point already said, Mr. Angus, you're out of time.
My microphone was still on, and I said I was moving a motion.
I didn't hear you say you were going to move a motion. I heard you. I said you were out of time. I was going to move to the committee to ask to the committee if they wish to go on to another round of questions. I will come back to your motion after we establish whether we want another round of questions. Folks, do you guys want another round of questions? Yes? Okay, so there's a desire for another round of questions. Mr. Angus, what is your motion?
I don't know if we need another round of questions. No, I think we're done. We're done. Yeah.
Well, so
Also, he's not a member of the committee.
couple of things. A couple of things. So just for clarity, though, Mr. Angus, you're not actually a member of the committee. Mr. Rankin is here, so you can't move a motion. Let's go with that. Number 2, the issues with respect to moving forward on another round. If there's a disagreement with that, then we would have, I guess, to have a motion and a vote. If we're not consensually moving to another round, do I have a motion to move to another round of questions, Mr. Boissonneau? Is there a debate on that? Is there any debate on that? All those in favor of moving to another round? Okay, so we're agreed to move to another round. Now, the next round. First of all, Ms. Wilson-Raybould, you've been sitting here for quite a while. Would you like a break?
I'm okay.
You're okay.
But,
You're okay.
If we get to
I
9
applaud
o'clock,
you.
I probably will have a different answer.
Please let me know if there is at any point you feel you need a break. So the next round, which would be going back to the way the first round goes, it's 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. Ms. Raitt? Ms. Raitt.
Thank you very much. I don't want to keep going over and over the same grounds, but if I could just summarize, and you can tell me if I've got this right or not. The reality is that for a significant amount of time, from the time you made your first decision to the time in which you were moved into Veterans Affairs, you had upheld the rule of law by withstanding the overtures and the entreaties of various people within the government, within the Privy Council office, within the staffing to the government. And as a result, we can draw the conclusion that your movement, not out of cabinet, but your movement within cabinet was as a result of the fact that you didn't play ball with them and deliver what the Prime Minister wanted, which was a solution for the SNC-Lavalin political issues that he had before him. Is that a fair summation?
I believe that committee members can draw their own conclusions, and I will not comment on conclusions of committee members.
Yeah, that's fair. At the very beginning, I asked you about witnesses that could potentially come forward. Of all the individuals that you have named helpfully and put brackets around, do you believe all of them would be able to give insight into what happened in these certain circumstances? Because there's conversations that they may have had that you weren't privy to that may help illuminate what was going on.
I'll answer it this way. I believe that individuals that I've named in my testimony, having been involved in those conversations or meetings, would have perspective about those meetings. And again, I think the more information that this committee has, and testimony from individuals that were directly involved is important.
So not a trick question, but do you have any knowledge of the friendship and relationship between Ben Chin and the Vice President of Government Relations for SNC-Lavalin? Do you have any knowledge that they go back to the McGuinty government and were great friends there? In fact, their relationship goes back further than their political interaction. Do you have any knowledge of that at all?
I have no knowledge of that.
Do you have any knowledge of the fact that Mr. Butts as well has a long-standing relationship with the VP of Governmental Affairs of SNC-Lavalin, and in fact they two worked together in the McGuinty government in the province of Ontario for a long period of time and probably know each other?
I have no knowledge of that.
Did you think it was odd that the Chief of Staff to the Minister of Finance would be requesting meetings with respect to your authority on deferred prosecution agreements or even in the conduct of criminal prosecutions? Was that a surprise for you?
I was aware of initial conversations that the Chief of Staff to the Minister of Finance had with my Chief of Staff. And I didn't consider it hugely problematic, but the sustained communication I did find problematic, and not sure why anyone from the Minister of Finance, the Ministry of Finance, the Department of Finance would be talking to my chief about something in terms of my role as the Attorney General.
Why do you think that the provision that amended the criminal code regarding deferred prosecution agreements ended up in the budget implementation bill and not in your criminal justice reform bill?
The deferred prosecution agreements and providing an additional tool to prosecutors was something that was being advanced by a number of ministers around the cabinet table, including the Minister of Finance. I, of course, as the Minister of Justice, am responsible for the criminal code, and as such, was part of the documentation and the discussions leading up to and including the introduction of the budget implementation bill with respect to deferred prosecution agreements, because I alone can change the criminal code.
Right. And did your department at the time have any input into the discussions around changing the integrity regime, which was out of Public Works? Was your department involved in that as well?
I can't be precise on the number of conversations that were had, but certainly the Minister Qualtrough was involved in the integrity regime. My department worked with hers around consultations, but the extent of that, I know that it was not a Department of Justice lead.
Yeah.
It was the lead of the PPSC.
Last question that I have for you. Out of all of the lobbying that happened on this, including, admittedly, with our party, SNC went in to talk to everybody, and I believe my colleagues as well were spoken to by SNC. I don't see your name on the list of those who were lobbied. Were there any requests made by the lobbyists of SNC to come in and visit you and talk about the issue of deferred prosecution agreements, given that you're the only one that can change the criminal code?
There was never a request.
Okay, thank you.
Thank you very much. Ms. Sahota?
Ms. Wilson-Raybould, I really do appreciate you emphasizing that our system is intact and there is a lot of integrity in our judicial system. I know that, after today's hearing, there are going to be those concerns raised, and you have testified to that. The clerk of the Privy Council has testified to that. But what I want to get into a little bit is that issue of responsibility that you have in your role as Attorney General. And today, we discussed, I think at some point in November, it seemed like you had, had enough contacts made and your mind was made up. Why, if you felt the issue was so serious, why did you not resign or pick up the phone and really have that serious conversation with the Prime Minister at that point?
Well, I made up my mind in September, and I articulated that to the Prime Minister. I felt no compulsion to resign because I was doing my job as the Attorney General. I had made a decision around my discretion and exercising it with respect to issuing a directive or taking over a prosecution around SNC and the deferred prosecution agreement.
Okay.
So
how about on January 7th, you said you had a conversation with the Prime Minister about changing your portfolio to Veterans Affairs. At that time, did you bring up your concern to the Prime Minister about what you felt the reasoning was for the change?
Yes.
Okay. But you still took on, knowing what you had known and feeling what you had been feeling. If interference was happening, if the pressure was so serious, and you had justified just now that the reason you resigned later on is because, not that you did not have confidence necessarily in the Prime Minister, or you wouldn't put it that way, but you didn't have confidence being at the cabinet table. Why was that decision made then and not at the time of that you were offered Veterans Affairs?
So I can't talk about any further about my resignation or any conversations or how I felt, because that's not covered in the OIC waiver that's been provided to the committee. But I did reflect on, while I was still the Minister of Justice and Attorney General, over beyond December the 19th and up to and including December 14th, about my role, about my concern and my uncertainty around whether or not the government or the incoming Attorney General, and I didn't know who that was at the time, and that's irrelevant, would enter into a deferred prosecution agreement with SNC. And as I said, if I had seen, which is required, a notice in the Gazette around a directive, I would have immediately resigned upon seeing that.
Okay. You bring it up the Saturday Night Massacre. I can bring up, we've had other attorney generals, a specific one in BC, Brian Smith, who faced some challenges, and what they did in their role, they felt their responsibility was to resign at that point. Did you not see it as your responsibility to resign if the issue was so serious?
At the time, I did not see it as my responsibility to resign. I saw myself as the Attorney General of the country who was doing her job to ensure and uphold the independence of the prosecutor and uphold the integrity of the justice system and the rule of law.
Okay. In November 4th, you had your 3-year anniversary of being sworn in. You put up a Twitter post about thanking the Prime Minister and what an honor it is to be in this role. To me, you also posted up your oath of the Privy Council, and within that oath, it said that I will treat all things to be treated, debated, resolved in Privy Council faithfully, honestly, and truly declare my mind and my opinion. Now, this is an oath you took, the Prime Minister also took. So in my mind, when I think about the conversations, I've never been there, around the cabinet table, I would think that as colleagues, you guys will have open discussions about the interests and acting on different files, making decisions, and the Prime Minister would be open and completely honest, just as you would be to him about what was happening. And in this regard, I feel like you had held back in your position, even though the Prime Minister had mentioned on several occasions his concern about the public interest, about the loss of jobs.
I can without equivocation say that I did not hold back as the Attorney General in this case. More broadly than that, as the Attorney General and also as the Minister of Justice, I always felt it appropriate to raise concerns, to engage in discussions and debate, and always speak, as I've said, my truth to power. I did that. In this particular case, I was entirely comfortable on September the 17th questioning the Prime Minister on whether or not he was politically interfering with SNC and DPAs.
And he said no, and so did you believe him at that point? Because on January 14th, you took on a new role as in another ministry.
Well, as I said, I took him at his word. I took him at his word after I directly questioned him in September, and took him at his word after I directly questioned him and Jerry Butts in January. I chose to take them at their words.
And so on January 14th, you also had faith and belief that there was no interference, and that's why you carried on with taking on a new role?
I had serious concerns about it. But again, I took the Prime Minister at his word.
Thank you, Ms. Hoda. We go to Mr. Cullen, and I just want to advise everyone that the NDP has advised me they have a motion they wish to put forward. After we finish the rounds of questions and we have no more questions, I will allow the NDP representative, who's Mr. Rankin, to put forward the motion, okay? So, Mr. Cullen, the floor is yours.
Thank you very much, Chair. Thank you, Ms. Wilson-Raybould, for your not only your testimony but your endurance today, as we've gone into some time. It's the directive you talked about. Ms. Raitt questioned about how rare it was and how unique it was. Can you say again that it has never been used in a specific case? Was that your testimony here today, that an Attorney General has never used the specific directive on a specific case, like as in the case of SNC-Lavalin? Is that right?
That's correct.
So not only is this tool incredibly rare, it has never been applied in the way it was being suggested by the Clerk of the Privy Council, all the other people that consistently lobbied you to use that tool. They're asking you to do something essentially historic.
An Attorney General has never issued a specific direction in a specific prosecution, nor has an Attorney General in this country ever issued a directive, taken over a prosecution. Right. It would be historic for the first time. It would be historic.
So what you were being asked for is not only extraordinary in this case, you were being asked to do something unprecedented. Is that fair?
With respect to a specific prosecution,
yes. Yeah, okay. I'm a bit confused by this line of logic that I've heard my Liberal colleagues just recently use. They're questioning essentially, I think, your integrity for not quitting. I thought your integrity was enhanced by not quitting, by staying there and, as you've just said, maintaining the rule of law. What am I finding confusing about this? You should have quit when you were being pressured inappropriately, consistently by some of the most powerful people in this country. You resisted that pressure. You said you were not going to give this plea deal, this special offer, and you stayed in the job. People are questioning your integrity for having taken that course of action. Do you understand my confusion and why Canadians might be confused?
I can say this. I have always acted with integrity, with purpose, and with principle. I was doing that in my role as the Attorney General when it came to SNC and the deferred prosecution agreement potential. I suspect that this committee will have discussions about the testimony and differences of opinions, but I also believe in Canadians and their ability to hear the words that I've spoken, hear the facts that I've expressed, to make their own determinations.
Okay, well, I think many of us are making our own determinations based on what we're hearing today. The ability to seek one of these special, I'm calling them plea deals, I'm not a lawyer, these deferrals, they can't be made for political reasons, is that correct?
That's correct.
It's illegal, in fact, for you to have made the decision based on political motivations, is that
It
correct?
would be unlawful for me to do that.
It would have been unlawful for you. Is it unlawful for someone to ask you to do that?
To ask, to direct me, or to ask
Pressure
me?
you? I mean, there's a line that's being contemplated. First, when this story first broke, the Prime Minister said everything is false. And then there was no pressure put. Oh, there was some pressure put. Don't worry, the clerk says it was appropriate pressure. All pressure to do something that we've heard from your testimony today that had political motivations, which would have been against the law for you to do as the Attorney General. Have I said anything wrong to this point?
No.
Okay, good. Is it illegal for someone to pressure the Attorney General to offer a special plea like this for political reasons? Is it illegal for someone just to pressure the Attorney General to intervene on a case?
In my opinion, it's not illegal.
Mm-hmm.
It is very inappropriate depending on the context of the comments made, the nature of the pressure, the specific issues that are raised.
Right.
It's incredibly inappropriate and is an attempt to compromise or to impose upon an independent Attorney General.
So there was pressure put. There was veiled threats you talked about. You repeatedly asked those threats to stop, those communications to stop with you and your office. Is that correct?
That's right.
And it continued. You said, I'm not doing this. I've already made up my mind. You have sound legal reason for your mind. You're upholding the rule of law. And the pressure continued. The veiled threats continued all the way through December. Is that correct?
It continued. I wouldn't say that the veiled threats continued throughout the time frame.
Oh.
There was an escalation in terms of the pressure or the attempts at political interference that culminated in the meeting on December the 19th.
So up until that meeting on December the 19th, starting way back in September, you had given notice, you've made your decision. The decision is already, the train has left the station. You're not going to interfere with the public prosecutor, the independence of the prosecution to do their job and uphold the rule of law. You ask for it to stop. It, in fact, escalates in terms of the pressure. Is that right?
That's correct.
Okay, so an independent, yeah, the independence of the Attorney General's office. I'm just reflecting on the Prime Minister's argument about the importance of the rule of law in Canada when dealing with Huawei, and that the argument consistently made by this Prime Minister was he had no choice because he so believed in the rule of law. At the very same time, he and his staff, his key advisor, and the clerk of the Privy Council, and others in his staff from the finance minister on down, are not respecting the rule of law and your independence as the Attorney General of Canada. I find the contradiction, the hypocrisy of this situation breathtaking. And I've seen a bit from Liberal governments. I thank you, Chair.
Thank you, Mr. Collin. So now we will go to Mr. Sassi.
Thank you, Mr. Chair. Now, my first question is you had an opportunity to speak to the abilities and the discretion of prosecutors. I want to ask you about the obligations of prosecutors. You're fully aware of the handbook for prosecutors, and those are your duties and expectations that you are passing on to prosecutors. In relevant part of that particular handbook, it says Crown Counsel must continually assess at each stage of the process whether the prosecution is in the public interest. So if they have an obligation to continually reassess, would you mind explaining to us why it's your opinion that when you made your decision on September 16th, it wasn't your obligation also to continually reassess the facts?
I am provided as the Attorney General with notices by way of Section 13 in the Director of Public Prosecutions Act from the Director about issues of general interest. I received, when I was the Attorney General, many of these notices. This is the director raising, as I said, issues of general interest, and saying that they are providing this information to me at the time as the Attorney General to do as I deem appropriate. I made my decision based on information that I received from the Director of Public Prosecutions by way of that note. I did my due diligence, again, was firm in the decision that I made. I have never said that it's not within the ability or the job or the discretion of a prosecutor to continue to evaluate the case that they have before them. Of course they can. It's the case in every prosecution. The prosecutor can act based on the circumstances, based on the facts, based on the input that is presented to them. I am not the prosecutor. I have the ability to be notified by the Director of Public Prosecutions by way of Section 13 notices.
Thank you. It would seem to me that that everyone who has this responsibility has an obligation to look at the facts as they change. Now, I had a question about timing. Again, if you could explain to us why you did not bring to anyone's attention your misgivings about the legal process until after you had been appointed to another portfolio.
I'm sorry, I don't understand the question. I am not at liberty to talk about anything after I was no longer the Minister of Justice and the Attorney General. When I was the Minister of Justice and the Attorney General with respect to SNC and deferred prosecution agreements, I did raise my concerns about the inappropriate nature of the interactions that I was having.
And when did you raise this?
From September the 17th through to, including the December 19th meeting, through to the January 7th meeting that I had.
So all your expressions of concern are the ones that you have detailed in your opening statement?
Well, I mean, I appreciate actually answering this question because I know that the letter from the chair was for me to come here and give my complete account. I have done my best to give my complete account, but there is, due to time, in terms of my opening statement, I had to confine my comments to certain expressions and meetings and details. That's not to say that it is a complete account of everything that was said, and certainly I have the inability to speak to anything that occurred after December or January the 14th.
And could you provide us with the basis as to why you think that everything that happened after you were appointed to a new portfolio is actually cannot be waived? What is the obligation that you cite?
I am not going to speak to that. I have received the order in council and the waiver that's been provided to me to speak about matters that would be covered by solicitor-client privilege and cabinet confidences to this committee and to the Ethics Commissioner for the time that I was the Minister of Justice and the Attorney General of Canada.
And thank you for that.
I guess just, I don't want to intervene, but I think that was, the question was so that the committee knows just on what basis, and I'm guessing that it's cabinet confidence because you wouldn't have solicitor client after you became Veterans Affairs Minister, would be on cabinet confidence, correct? Is that what?
Every conversation that I may or may not have had when I was the Minister of Veterans Affairs with the Prime Minister or not with the Prime Minister, up to and including the meeting that I had with my then colleagues around the cabinet table, would be covered by cabinet confidence.
That's, I think, what he was trying to get out. Thank you. So we now have a question. Do we move to another round, colleagues? Yes or no? Yes? Yes? Agreed? So this round, first, before I do that, Ms. Wilson-Raybould, do you need a break?
I mean, I'm happy to go another round, but probably after that, I will ask that
But if you need
we
one now-
reconvene at another time, and so we can
Of course.
continue
But
the
if you
discussions.
need one now, I'd be very happy to give you a 10-minute break. Would that be helpful in any way?
Actually, I'd prefer not to have a break.
okay.
I do have to say, and again, I'm happy to answer questions, but the nature of the questions seem to be very similar, and we're continuing to go over the same ground. If they're, and I'm happy to continue to answer those questions, but I just wanted to put that out there. But if there is another round after this one, I would ask the committee that that I be able to come back and answer questions.
I understand, and and the committee will definitely take that into consideration on its decision after this round. But I think we can perhaps look at this being then the last round for today. So this round is 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So, Ms. Khaled? Oui, Monsieur Ford. Oh, excusez-moi. Oui.
Yes, I'm sorry. I promised Mr. Fortin, who'd been at our meetings previously and asked for some time to speak. We gave him 3 minutes after the last round of questions.
Of the committee, do we agree that at the end of this round, that we give 3 minutes to Mr. Fortin, 3 minutes to Ms. May, and 3 minutes to the Cooperative Commonwealth Federation for its first questions in Parliament in 50 years in a committee? Is that okay with everyone? Is that okay with you, Ms. Wilson-Raybould?
Absolutely.
Thank you very much. So we will start with the Conservatives. Sorry, Liberals, Ms. Khaled, I'm sorry. We're round 6, Ms. Khaled.
Thank you, Chair, and thank you, Ms. Wilson-Raybould. We really do appreciate your patience and you continuing to stay on here, as I'm sure that Canadians have a lot of questions and to get a lot of your truth out. You had mentioned in the meeting with Jessica Prince and the Prime Minister's Principal Secretary and Chief of Staff that when your Chief of Staff left that meeting, she was very upset, and with respect to kind of understanding what that was and what measures could have been taken at that point. The clerk said also, Mr. Wernick, that in his testimony he'd listed out some of the remedies that were available. He talked about going to the Prime Minister and speaking and having that tough conversation with the Prime Minister. He talked about picking up the phone and calling the Ethics Commissioner, and he said ultimately as a last resort resigning. And I don't think anybody expected you to resign, but we're just trying to understand kind of the context and how you were feeling as you were going through all of this. Earlier in my questions to you, I had asked if you had spoken to the Prime Minister from your September 17th meeting going up to the time when he spoke to you with respect to your new appointment. My question really is, why didn't you speak to the Prime Minister during all of that, as all of this was building up, as you've indicated, as all of these things were happening? Why did you not speak to the Prime Minister? Why did you not call the Ethics Commissioner? You are concerned, and as you rightly should be, about the rule of law. Why didn't you take any of those measures? It didn't have to be to the point of resignation.
Well, I won't deal with it to the point of resignation. But again, I did raise this with the Prime Minister directly on September the 17th. And from that point through to and including December the 19th, there was a sustained and continued attempt to politically interfere. Those meetings consisted of many people within the Prime Minister's office, including the Principal Secretary to the Prime Minister and the Chief of Staff, in reference to the meeting that you talked about with my Chief of Staff, then Chief of Staff, Jessica Prince. Yes, she was upset when she came out of that meeting because of the continued and escalating pressure and interference that was placed on her to relay back to me as her minister from the principal secretary and the chief of staff. Those conversations included the principal secretary saying that this situation would not be resolved without some kind of interference. And the other statements from that meeting are contained within my opening testimony. It was my understanding, after I had had the opportunity to speak with my then chief of staff, that there would be potentially a meeting or a call the next day, because I was in Vancouver, with the clerk of the Privy Council and the Prime Minister. So I was waiting to get a call from the clerk and or the Prime Minister. That call happened with the clerk, who invoked the Prime Minister's name throughout the entirety of the conversation. That call ended. The next discussion that I had, and everybody was going on holidays, I was confident in the knowledge that there would not be any interference with the discretion, because I was the Attorney General and I'd made my decision. We all went on holidays. The next conversation that I had was on January the 7th with the Prime Minister, where I raised this issue.
You've been able to reach out to the Prime Minister in the past, but I still don't understand why you didn't reach out to him when this was such an important issue. It was not raised with the Ethics Commissioner either. But please pardon me, I have not been able to get clarity on this. I just want to flip to one other thing that we have spoken about today, and it is with respect to remediation agreements, which my colleagues have addressed at length. Do you agree with remediation agreements in principle?
I was part of a cabinet that brought in the additional tool to prosecutors that they could utilize, and that tool was deferred prosecution agreements.
So you do agree with deferred prosecution agreements in principle?
I do not believe that my personal opinion on deferred prosecution agreements is relevant.
Well, I think with the scope of the motion, it may be relevant for us to consider. The motion? The whole reason why we're here today, with the motion speaking specifically to understanding the nature of remediation agreements, of deferred prosecutions, etc. And I do believe that you had voted in favor of deferred prosecution agreements as part of the budget bill.
Well, that's clear. I already said that I did. I was part of a cabinet that brought this tool in, and Parliament passed the legislation, and the criminal code was amended in September of 2018. I would submit that discussions around deferred prosecution agreements are irrelevant to this discussion. What is relevant to this discussion, and that's the discussion that we've been having now for some time, is the role of the Director of Public Prosecutions, the role of the Attorney General of Canada, and the necessary independence that is a constitutional principle for prosecutors to be upheld. I believe that is the relevancy of this discussion, not whether I agree or disagree, or any member of this committee agrees or disagrees with the tool of deferred prosecution agreements.
Thanks for clarifying that, Ms. Wilson-Raybould.
Thank you very much. Mr. Barrett?
Ms. Wilson-Raybould, thank you very much for your extended testimony with the committee. Is it your assessment that the Prime Minister has been accurate and truthful in his statements concerning this issue?
I'm not going to comment on statements of the Prime Minister or anyone else as to their validity.
Okay. And Mr. Chair, we'll cede the rest of our time. Thank you.
Thank you very much. If the Conservatives are ceding the rest of their time, that goes back to the Liberals. Who is up? Mr. Boissonnault.
Thank you very much, Mr. Chair. Madame Raybould, j'ai une question pour vous en français.
Ms. Raybould, I have a question for you in French. In your role as Attorney General, have you ever, when you were Attorney General, did you ever receive advice from sources outside of government, lawyers, attorneys, from outside with regard to Canadian law or bills?
Minister of Justice and the Attorney General of Canada, I have received advice from external lawyers. I have taken it upon myself to foster relationships with previous ministers of justice and attorney generals of Canada. I, again, feel it's very important to have a diversity of views about particular issues, and I welcome feedback from individuals, particularly where it has to do with putting forward legislation and changing the criminal code, for example.
Thank you very much. You mentioned in the document at the beginning of this session, your testimony, that you conducted a period of due diligence. Could you share with us who you conducted due diligence with in this SNC-Lavalin matter?
I don't feel it's appropriate to share that.
But it's the privilege has been waived, and so is cabinet confidence. So who did you consult with?
Why I don't feel it's appropriate to answer that question is because it gets into discussions around the nature and the content of the Section 13 notice that was provided to me as the Attorney General from the Director of Public Prosecutions, gets into topics that are right now before the courts.
Okay, but back to my earlier line of questioning, which was this issue of, the openness to receiving new information and making sure that there is never a final decision. Let's look at this a different way. What is the number of individuals that you consulted with during the due diligence before you came to what you have told us is your final decision, even though the law permitted you to continue to look at having a deferred prosecution agreement, and you have said very clearly that the principles of law indicate that you need to have an open mind before there is a final decision. And in fact, it can't ever be a final decision. So how many individuals did you consult with in your due diligence?
Well, actually...
Sorry to interrupt. With apologies to Mr. Boissonneau. There was a question raised specifically about external references. The witness, Ms. Wilson-Raybould, said because it's sub judice, it's before the courts, she was unable to comment on it. And Mr. Boissonneau continued. We've heard... This is a totally different matter.
Totally different line.
Now you're asking for numbers, you're asking for specific...
The issue of external...
I'm not actually addressing you, Mr. Boissonneau. I'm talking to the chair.
I understand. So let Mr. Cullen finish his point, and then I'll...
So when a witness is asked a specific question, and then the question is reframed, but essentially the same question, the witness has already said this is sub judice. We're now 3.5 hours into this meeting. It seems strange to me that an argument that has been used often to prevent witnesses from testifying at this committee, sub judice, the argument, is now being offered up by the witness in front of us, and it's not being accepted. The questioning continues. And oftentimes, as you know, Chair, when a witness says, I'm unwilling or unable to answer a question, we as committee members simply accept it at that.
So a couple of things. I don't recall any witness having been refused to this committee in 3.5 years on the sub judice rule, so that is not correct. With respect to Mr. Boissonneau's question, he's attempting to rephrase the question in a different way. I will alert everybody again that Ms. Wilson-Raybould made the point that the sub judice rule applies to specific questions with respect to SNC-Lavalin, that we do not want to have an impact on the appeal of SNC-Lavalin on their questions of the remediation agreement, and therefore her specific interactions with the Department of Public Prosecution and others within the Department of Justice would not necessarily be... the committee can do what it wants. It's the master of its own domain. Everybody can ask those questions. That's a restraint that we choose to put on ourselves. So there's nothing either unfair of him trying to rephrase his question. I'd encourage him to do it in a different way, or alternatively, for the witness to refuse to answer the question on that basis. And that's where I think we should go. We have 3.5 more minutes on Mr. Boissonneau's testimony, Mr. Boissonneau's questions. Mr. Boissonneau.
Thank you, Mr.
Ms. Wilson-Raybould, if you think he got his question finished, you're more than welcome to answer it.
I will say what I was going to say prior to the discussion of committee members. Mr. Boissonneau, I am not trying to be evasive. I take incredibly seriously my responsibilities as a member of Parliament. and to have conversations about what I did and didn't do around due diligence with respect to a Section 13 notice. I think that with respect, the committee should realize that at the time I was the Attorney General of the country, and which makes me different than anybody else with respect to that circumstance. And it would be very inappropriate for me with respect to go into any of these discussions.
I appreciate that. I appreciate the answer. And my question to you is this. Once you made your final decision, and you mentioned that in your testimony, would you say then that your mind was closed to new information and a new context?
I had made my decision where to not interfere with the decision and discretion of the Director of Public Prosecutions. I was made aware as the Attorney General about general interest prosecutions by way of Section 13 notices from the Director of Public Prosecutions. I had made my decision on this particular matter. That is not to say that the prosecutor in this case or any other case does not continue to work on the case, to take in new information, to have discussions with whomever they deem appropriate throughout the course and the evolution of a prosecution up to and including a potential trial.
Thank you. Can you tell us where you memorialized your decision to not proceed with a deferred prosecution agreement in this matter?
Where I memorialized
Like where you made a memo or indicated that today's the day, we're done, my decision's final. Where would you have recorded that?
Well, this is not a direct answer to your question, but I take copious notes.
So it's in your notes somewhere?
Day. I am faced with many Section 13 notices, or was when I was the Attorney General.
A question for you then is, did the Prime Minister, the Clerk, or the PMO ever direct you to enter into a remediation agreement with SNC-Lavalin?
No.
Thank you. Thank you, Mr. Chair.
Thank you very much. We now go to the Conservatives. Mr. Cooper.
Great. Thank you, Mr. Chair, and thank you again, Ms. Wilson-Raybould. A number of members opposite have repeatedly raised the specter of these conversations as somehow being in relation to the public interest and therefore somehow appropriate. And I just want to ask you, are factors such as the Quebec election, finding a solution for SNC, as the Prime Minister stated when you met with him on September 17th, the fact that the Prime Minister is a member of Parliament from Montreal, the fact that SNC-Lavalin's council is not a shrinking violet, or as the Clerk of the Privy Council informed you on December 19th, quote, I think he is going to find a way to get it done one way or another. So he is in that kind of mood, and I wanted you to be aware of that. Are any of those things appropriate considerations in exercising your prosecutorial discretion with respect to the public interest?
Those are not appropriate.
Mr. Cooper. Next is Mr. Rankin.
Well, we've been here, Mr. Chair, for now several hours, and I think I'd like to move the motion rather than take the time to do so later. I would not use my time for anything but to make the motion at this point.
The motion, there is no problem. But remember, we had said Mr. Fortin, Mrs. May, and Mr. Weir. So would you like to wait on your motion?
I'd like to move the motion in the time allotted to me, and then I'd like to have a vote if there's a need to do so. And then, of course, we'll hear from the others as we've agreed.
Okay. I mean, that's fine with me. You have a right to move a motion within your time. I'm only pointing out that requires the witness then to stay here for those last questions as opposed to liberating
This is a short motion. And it goes like this, Mr. Chair. In the interest of transparency and accountability, I move that the Justice Committee call upon the Prime Minister and the Governor-in-Council to extend the waiver of solicitor-client privilege and cabinet confidentiality relating to the SNC-Lavalin issue so that the former Attorney General can inform the Justice Committee of any relevant information with respect to the period subsequent to her ceasing to serve as the Attorney General of Canada on January 14, 2019. In other words, Mr. Chair, we've got to a certain point and we've been told that thereafter we cannot ask questions and the witness cannot tell us what happened. I think the evidence is abundantly clear that we need to know that, and therefore I'm moving that this committee request of the Prime Minister and the Governor in Council that that order in Council be altered accordingly.
Thank you very much. What I'd first ask is, does anybody need time to consult and discuss this motion within themselves, or is everybody good to go ahead and debate and vote? I'd like a recorded vote. Ms. Khaled?
If it's okay with you, can we just confer amongst our Liberal
That's what I
colleagues
was.
for 5
That's what I was
minutes?
asking. So,
Thank you.
can I ask the question again, Mr. Rankin? You moved the motion. Can we ask the last three questioners to go?
Yeah, that's fine.
And then have just a brief pause for the consultation.
Certainly, I just wanted to get the motion
course.
on the record, and I'm more than happy to consider it a notice of motion. But I would like to. I would request that we come back to it immediately after the testimony today.
Absolutely. So what I'm suggesting is let's have Mr. Fortin, Madame May, and Mr. Weir get their 3 minutes in. Let the witness be liberated, and then we can come back to this and just have a brief. A brief pause. The word "liberated" is probably not the right word. So thank you very. Who goes? Qui veut aller premier? Monsieur Fortin première, Madame May.
Mr. Fortin first.
Gaila Kessler, I want to ask something that's just very clearly, and then I move to a different line of questioning from what others have been asking. And that is, first of all, do you believe that individually or collectively the pressure to which you were subjected contravened the criminal code?
I don't believe that.
Okay. Mike, there are a lot of power relationships we've been discussing, and most of the questions have gone to the power relationships around political actors, the Chief of Staff, the Principal Secretary of the Prime Minister, your role as both two hats, judicial hat and cabinet hat. But there's a very prominent role being played by, I think, unusual actors in the civil service, where the power relationship is the clerk of the Privy Council is the boss of the Deputy Minister at the Department of Justice, and down through the chain, with you essentially, I think, acting as a bulwark to protect the independence of the Director of Public Prosecutions. What I wanted to go back to in your testimony, there are a couple of places where you mentioned some things, and I wondered if they were concerning to you, and if so, why. So in chronological order, you mentioned that on September 7th, the Deputy Minister was able to have certain sections of the Section 13 notice read aloud to her, but she did not want to receive or be given a copy of it. Was that in any way concerning to you? It's included in your testimony. I just wanted to pursue it.
Yes, that was a concern.
And why were you concerned?
Well, as the Minister, as the Attorney General, I worked very closely not only with my Chief of Staff, but with the Deputy Minister. And this applies to my then Deputy Minister and the Clerk of the Privy Council when public servants get involved in political discussions. Of course, I have concerns, and I believe it's inappropriate.
So going to September 17th, you described the meeting which you had requested of the Prime Minister on a different topic was supposed to be a one-on-one meeting, by which I infer you did not expect the Clerk of the Privy Council office to be present when you went to meet with the Prime Minister. Is that correct?
I didn't expect that, but I will say that the fact that he was there, I didn't ask him to leave.
Okay. So in the context of the pressure that was being applied and the political concerns that were being raised, I'm going to put forward a positive statement, see if you agree, that the appropriate role for the Clerk of the Privy Council office is to support the Attorney General who says, you're in a dangerous ground here. Back off, this is political interference. The job of the civil service is to remain nonpartisan and give good advice. Did you think the Clerk of the Privy Council was behaving appropriately in applying political pressure to anyone in this case?
I did not believe that he was behaving appropriately, which is why I was very surprised when he raised issues of the Quebec election and a board meeting that was supposedly happening with SNC.
Do you believe that the Clerk of the Privy Council appeared to be placing your Deputy Minister of Justice under pressure that could have affected her confidence in her job security?
Honestly, I don't believe I can answer that question.
And lastly, you said that you
You got to wrap up. That's your you're sort of over your time.
Okay.
Thank you very much. Monsieur Fortin.
Merci.
Thank you. Ms. Wilson-Raybould, I also want to thank you for your presence here today, and I want to underscore that testifying like you have done today requires a lot of courage, and I appreciate that. Having said that, I have questions that may go in a different direction, but I'd like to get back to your motivation for your decision. There are some things you can't tell us, I understand that, but my first question is the reasons why you felt that it was not appropriate to come to an agreement with SNC-Lavalin after having looked at the criteria of Section 715 of the Criminal Code?
And the question, all I can say with respect to the question was that I did not believe, based on the Section 13 notice that I received from the Director of Public Prosecutions and the due diligence that I undertook, that it was appropriate with respect to SNC to issue a directive and intervene in the prosecution, to intervene in the discretion that was exercised by the Director of Public Prosecutions.
Est-ce que vous avez discuté?
Did you discuss the reasons why you felt that this was not appropriate to have such an agreement? Did you discuss this with the Prime Minister or someone else in the Prime Minister's office, for instance?
I did.
Est-ce qu'on peut savoir avec qui vous?
Can you tell us with who you discussed this?
I discussed it with the Prime Minister, with the Clerk of the Privy Council, with Elder Marquez, with Mathieu Bouchard, among other individuals, including the principal. Well, indirectly, my Chief of Staff, Jessica Prince, discussed it with the Principal Secretary to the Prime Minister, as well as the Chief of Staff to the Prime Minister, as well as the Chief of Staff to the Minister of Finance.
Et je comprends que vous.
I understand that you feel that you can't tell us today what these motivations were, why you felt that there should not be any negotiation.
I felt at the time and made the decision that it was inappropriate for me as the Attorney General to interfere in the discretion that was exercised by the Director of Public Prosecutions with respect to SNC and the decision that was made to not enter into negotiations around a deferred prosecution agreement.
Merci beaucoup. Monsieur Fortin?
Mr. Fortin, I'm sorry, but you're 3 minutes. 3 hours and 3 hours and a half, and you can't give me 30 extra seconds? I'll give you 30 seconds more. Just 30 seconds. So that everybody knows. I want to understand Ms. Wilson-Raybould's testimony. It seems to be important for all the citizens to understand that aspect of the situation. This is pretty surprising here. Now, I'm not saying your question isn't important. I'm just stating the fact that your 3 minutes are up. I'll give you 30 seconds more if you wish. Ms. Wilson-Raybould, 30 seconds. I'm sorry, but your decision not to intervene, was it based on one of the conditions of application under the Criminal Code for negotiations of a remediation agreement? That's under the sub judice rule. No, I'm sorry, it's not. I wasn't asking her what the reason was. I was wondering whether that's within the criteria. She can answer if she wants. Thank you, Mr. Chairman. I'll allow Madam Wilson-Raybould time to answer.
Thank
Merci,
you.
Madame Wilson-Raybould.
Mr. Weir.
Well, thanks very much for the opportunity, and Ms. Wilson-Raybould, thanks very much for your extensive and informative testimony. I'd like to ask you to expand a bit on the idea of separating the role of Attorney General from that of Minister of Justice. It seems that under our current system, the Prime Minister could choose to appoint two different people to those posts. Is that what you would recommend, or do you envision making the Attorney General an officer of Parliament, or somehow officially separating it from the government?
Well, I don't want to get too far in advance. I really hope that the committee will consider looking at studying this. I always try to look for ways to move forward. I think that it would be entirely appropriate for this committee to look at different models internationally. I mentioned the United Kingdom, where the Attorney General is not a member of Cabinet. The two hats that the Minister of Justice and the Attorney General wears here in our country are completely different, and I think there would be merit to talking about having those as two separate individuals. Obviously, after much discussion and study, the prerogative of the government of the time, what they would choose to do in that regard, and the Prime Minister.
Is that an ideal you ever floated to the Prime Minister or to the Clerk of the Privy Council office?
I would say no, because I can't remember a concrete discussion where we had. But there have been times where I have raised the issue internally when I was the minister with individuals, and potentially I could have had conversations with other colleagues.
Okay. Now, you were asked about whether you supported deferred prosecution agreements, and I don't want to push that question again. I do want to ask, though, if you could describe what the ideal candidate for a deferred prosecution might be.
Well, I think that it's the tool of a deferred prosecution agreement and considerations that the Director of Public Prosecutions or prosecutors can take into account are delineated and articulated within the criminal code.
Okay. No, that's good for me.
Thank you so much. So I want to take this opportunity to thank Ms. Wilson-Raybould very much for her testimony. It's very much appreciated.
Thank you.
And now we are on Mr. Rankin's motion, and we've been asked for a short pause to consider discussion. So can I just say the meeting is suspended for 5 minutes? 5 minutes. Meeting is resumed and unsuspended.
Okay.
Mr. Rankin.
I don't know
floor is
if you need me to read the motion again, Chair.
Sure, why not read it for
I'll
the
just
record?
read it again. In the interests of transparency and accountability, I move that the Justice Committee call upon the Prime Minister and the Governor in Council to extend the waiver of solicitor-client privilege and cabinet confidentiality related to the SNC-Lavalin issue so that the former Attorney General can inform the Justice Committee of any relevant information with respect to the period subsequent to her ceasing to serve as the Attorney General of Canada on January 14th, 2019. That is my motion.
Thank you very much. Any debate on the motion? Ms. Khaled.
Chair, thank you very much, and I think that this whole exercise has been to really shed light on the issue at hand, and we take this very seriously. Now, our original motion talked about meeting after Ms. Wilson-Rayble's testimony to discuss next steps, and I think that it's more appropriate that we talk about this as part of our next steps conversation so that we know and we're not badgering or we're not trying to elicit information that may or may not be there. I think we should have that meeting, us as committee members first before we go there. So I think that at this time it's appropriate that we vote down this motion and revisit the idea at our next steps meeting.
Mr. Rankin?
Therefore, I call the question, Chair.
Okay. Calling the question is I mean, I understand. I understand. Unless there's no further interventions, I can't quite call the question. But I don't know that there are. Is there anybody who really wishes to speak to this? Not hearing any. We'll move to the vote.
Oui, avec plaisir, Monsieur le Président. Monsieur.
With pleasure, Mr. Chairman.
Mr. Sassi.
No.
Ms. O'Connell.
No.
Ms. Khalid.
No.
Ms. Saota.
No.
Mr. Barrett.
Yes.
Mr. Cooper.
Yes.
Monsieur Paulus.
Oui.
And Mr. Rankin.
Yes.
Yeas 4, nays 5, 5.
So the motion is defeated. Colleagues, one thing that I would suggest is we have not yet sent out the notice of motion for tomorrow's meeting. I think it will be difficult to digest all of Ms. Wilson-Rayble's testimony for 8:45 tomorrow morning and come back and to consider next steps. May I consult with the vice chairs and come back with a time for the meeting that's a little bit perhaps later in the day?
I think that's a great idea.
Thank you. Okay, so if there's nothing else, folks, meeting adjourned.